Thank you. Good morning, everyone. I'm going to call the Assembly Committee on Judiciary to order. Madam Secretary, would you please call the roll?
Assemblywoman Bilbray Axelrod.
Here.
Assemblywoman Cohen.
Here.
Assemblywoman Gonzalez.
Here.
Assemblywoman Hanson.
Here.
Assemblywoman Hardy.
Here.
Assemblywoman Kasama.
Here. Here.
Assemblywoman Krasner.
Here.
Assemblywoman Marzola.
Here.
Assemblyman Miller.
Here.
Assemblywoman Wynn.
Here.
Assemblyman O'Neill.
Here.
Assemblyman Orentlicker.
Here.
Assemblywoman Summers Armstrong.
Here.
Assemblyman Miller. Assemblyman Wheeler.
Here.
Chairman Yeager.
Here. Assemblywoman Hanson, if you're being held hostage, please let us know.
April Fool.
Chairman Yeager, how are you, sir? For those
Good.
now, I haven't met most of you, frankly. There was a time when I was the chair of this committee, and your chair was actually a terrific witness to a public defender. Public defender Steve Yeager. And I think that if I ever got in trouble with the law, I would love to hire him because he could even make me look innocent. So, pardon my interruption. Great job. Say hi to Diane and Bonnie and Brad and Cheryl. Nice to see you all. April Fool's Day.
Good to see you, Senator. I'm sure we'll be seeing you soon over in your committee. And we do have Assemblywoman Hanson present. That means everyone is here. We have a quorum. Good morning, everyone. It is day 60 of the 81st session of the Nevada Legislature, which means we've made it to the halfway point. So pat yourself on the back for that. And again, welcome to committee members, to those joining us on the Zoom, and to those who may be watching over the internet. Before we get started on today's agenda, let's just go over a few quick housekeeping rules. If you're on the Zoom with us, please mute if you're not speaking. If you are presenting a bill today or answering questions, please remember to state your name each time before you speak. We do expect courtesy and respect in our interactions with one another. We don't always agree on bills and policy. That's perfectly fine, but we need to make sure we're being respectful of one another, the legislative process, and of our staff. And finally, keep in mind that many members will be using multiple devices to access this meeting, so please don't see it as a sign of disrespect if members appear to be looking away. So let's move on to our agenda. We have a lot on there this morning, and just so everybody knows how we're going to handle this, we're going to do the work session first. And then after that, I believe we're going to do Assembly Bill 403, followed by 407, then 394. So we're kind of all over the place this morning. We do have some members who I know have to step out at some point in the meeting to present bills and other committees. It's just simply that time of the session. So if you see folks who are leaving the meeting, that's likely what is going on, and they'll be back when they're done presenting. So with that behind us, let's go to the work session. Members, you do have the work session document up on Nellis. It is there as a complete document, and then each individual bill has its own exhibit as well. So at this time, I'm going to turn it over to Ms. Thornton to take us through the work session. Before we do that, though, I did want to note I am going to pull Assembly Bill 339, so we are not going to work session Assembly Bill 339 quite yet, so look for that probably next week. But we do intend to work session everything else on the agenda. So Ms. Thornton, if you could start with Assembly Bill 7, please.
Thank you, Chair. Again, Diane Thornton, Legislative Council Bureau Research Division. Our first bill on work session is AB 7, and this bill was sponsored by this committee on behalf of the Gaming Control Board and heard in committee on February 23rd. This bill revises definitions associated with the intercasino link systems, thereby subjecting such system to the same regulations as associated equipment. The bill also revises certain provisions related to the live entertainment tax. There is one amendment proposed by Michael Morton from the Nevada Gaming Control Board. This amendment adds a new section relating to the applications for and the regulation of approval of games or gambling games by the Nevada Gaming Commission. It removes certain offensive names of games or gambling games from statute, deletes Section 22, and deletes Section 23 of the bill. Thank you, Chairman.
Thank you, Ms. Thornton. And, really the only section I think that only changed to the amendment that was different than when we heard the bill was the removal of Section 22, which deals with the live entertainment tax. And one of the reasons we did that is there were some implications for revenue and potentially for the state budget. So I have committed to keep working on that issue, but I don't want to hold up the policy part of the bill due to the financial aspect of that. So I think everything else is the same as when we heard the bill, but I would certainly take any questions from committee members on Assembly Bill 7 as detailed in the work session document.
Mr. Chairman, just one quick one, if I may.
Please go ahead, Assemblyman Wheeler.
I don't believe that it does, but I want to. Does this still removes the cap on the fees? There used to be $1,000 cap on the fees. I don't think that had anything to do with the live entertainment tax, did it?
I think you're right, Assemblyman Wheeler. I don't think that had anything to do with the live entertainment tax section. That had to do with tickets and how tickets are listed. So I think you're correct that it still does remove the cap on the fee.
Okay, thank you very much. I'm going to have to go no on that one. Thank you.
And let me just note, I think, did we have Mr. Morton with us?
Yes, Chair Yeager, Mike Morton for the record.
Oh, there you I'm sorry. Sorry, Mr. Morton. I was looking at one of the screens that wasn't turned on. So I'll give you a chance to address that too. I want to make sure I got that question accurately.
You did. The provision that Assemblyman Wheeler is addressing is a change in the way that we register those that are manufacturing or distributing associated equipment. We are making their registration process the same as all other registration processes that come before the board, and that those fees are set by the commission. The fees and the renewal period is set by the commission.
Thank you, Mr. Mortensen. I really appreciate that.
Okay, do we have additional questions on Assembly Bill 7? I don't see questions. I'd take a motion to amend and do pass.
I move to amend and do pass.
I'll
That was
second.
me, Assemblywoman Wynn.
I have a motion from Vice Chair Wynn, a second from Assemblyman Miller. Any discussion on the motion? Okay, I don't see discussion, so Madam Secretary, please conduct a roll call vote.
Assemblywoman Bilbray Axelrod.
Yes.
Assemblywoman Cohen.
Yes.
Assemblywoman Gonzalez.
Yes.
Assemblywoman Hanson.
No.
Assemblywoman Hardy.
No.
Assemblywoman Kasama.
Yes.
Assemblywoman Krasner.
Yes.
Assemblywoman Marzola.
Yes.
Assemblyman Miller.
Yes.
Assemblywoman Wynn.
Yes.
Assemblyman O'Neill.
No.
Assemblyman Orentlicker.
Yes.
Assemblywoman Summers Armstrong.
Yes.
Assemblyman Wheeler.
No.
Chairman Yeager.
Yes, motion does carry. I believe we had 4 noes on the bill. The rest were yeses. So again, that does carry. I'll assign the floor statement on Assembly Bill 7 to Assemblywoman Cohen. Ms. Thornton, could we go to Assembly Bill 8 next?
Thank you, Chair. Assembly Bill 8 was sponsored by this committee on behalf of the Gaming Control Board and heard in committee on February 23rd. This bill revises certain definitions, including credit instrument, slot machine, wagering voucher, and gross revenue. The bill also expands who is required to register with the Gaming Control Board. There is one amendment to this bill proposed by Michael Morton from the Gaming Control Board, and this Amendment revises the definition of gross revenue in Section 3 of the bill by deleting references to contests and tournaments held in conjunction with interactive gaming.
Thank you, Ms. Thornton. Any questions on Assembly Bill 8 as detailed in the work session document? Don't see questions. Would take a motion to amend and do pass.
I'd so move to amend and do pass.
And is there a second?
I'll second.
Okay, a motion from Vice Chair Wynn, a second from Assemblyman O'Neill. Any discussion on the motion? I don't see any discussion. Madam Secretary, roll call vote, please.
Assemblywoman Bilbray Axelrod,
Yes.
Assemblywoman Cohen,
Yes.
Assemblywoman Gonzalez,
Yes.
Assemblywoman Hanson,
Yes.
Assemblywoman Hardy,
Yes.
Assemblywoman Kasama,
Yes.
Assemblywoman Krasner,
Yes.
Assemblywoman Marzola,
Yes.
Assemblyman Miller,
Yes.
Assemblywoman Wynn,
Yes.
Assemblyman O'Neill,
Yes.
Assemblyman Orentlicker,
Yes.
Assemblywoman Summers Armstrong,
Yes.
Assemblyman Wheeler,
Yes.
Chairman Yeager.
Yes, motion does carry. It was a unanimous vote. I will assign the floor statement to Assemblywoman Hanson. Ms. Thornton, could we go to Assembly Bill 42 next?
Assembly Bill 42 was sponsored by this committee on behalf of the City of Henderson and Hardin Committee on March 10th. This bill requires certain batteries, which constitute domestic violence, to be charged with certain felonies and gross misdemeanors. The measure also establishes a right to a jury trial under certain circumstances and prohibits a person convicted of a battery which constitutes domestic violence or the same or similar conduct in another state from owning or having any firearm in his or her possession or under his or her custody or control. There's one amendment to the bill proposed by Nicole Rourke from the City of Henderson. This amendment provides that the minimum number of jurors is 12, but the parties prior to juror selection may stipulate any number less than 12 but not less than 6 in Section 3 of the bill. It adds chief marshal to various sections of the bill regarding jury deliberation room and jury summons process. It revises the definition of domestic violence, and lastly, it authorizes a justice of the peace to direct jury summons countywide. Thank you, Chair.
Thank you, Ms. Thornton. Any questions on the Assembly Bill 42 as detailed in the work session document?
Chair, if I may, PK O'Neill.
Please go ahead, Assemblyman O'Neill.
I don't know if it's really a question. I appreciate the work and the amendments given, but I'm going to be voting no on this. I think there's still room to do. The first half on jury selections, I think, is excellent, but I think we're creating confusion among the states and citizens as they travel with not staying with the federal regulations or federal rules. So I'll be voting no.
Thank you, Assemblyman O'Neill. We'll note that for the record. Any other questions? We will have a time for discussion. So if there are questions, I would take those now, and then I'll take the discussion after we take the motion. So any questions? It's perfectly fine. I just saw others raising their hand, and I thought they might say the same thing. So we'll give them a chance to do that under discussion. But questions on the bill as detailed? I don't see questions. So at this time, I'll take a motion to amend and do pass Assembly Bill 42.
I'd move to amend and do pass.
I'll second.
So I have a motion from Vice Chair Wynn. We have a second from Assemblywoman Gonzalez. We have the prior comments from Assemblyman O'Neill. I saw that there were some other folks who wanted to comment. Let's go to Assemblywoman Krasner.
Thank you, Chair Yeager. As some of you know, I've worked for years for domestic violence victims, human trafficking victims, sexual assault victims, child victims of sexual abuse. And so for me to ever vote no against domestic violence victims, I just don't feel good about that. However, I do still have a few concerns about this bill, and I hope the parties will continue to work together to maybe amend just the sections that are not quite right, but I will be voting yes to get it out of committee with reserving my right to change prior to floor. Thank you.
Thank you, Assemblywoman Krasner. Assemblyman Wheeler?
Thank you, Mr. Chairman. I just, in the order of brevity, I'll just say ditto to what Mr. O'Neill said.
Thank you, Assemblyman Wheeler. Assemblywoman Hardy?
And I will say ditto to Assemblywoman Krasner's comments. Thank you.
Thank you, Assemblywoman Kasama?
Ditto to Krasner.
Thank you. Any other discussion? So I think we had two with the Assemblyman O'Neill faction and 3 with the Assemblywoman Krasner faction. So I think that covers us all. Okay, so, and before I take the vote, I will say I have encouraged the parties to continue to work on this legislation as well. I think it is time to move it out of Assembly Judiciary, but of course, it's still got a little ways to go in the process. So I believe those discussions are ongoing, and we'll cross our fingers that they can reach some kind of consensus before the end of session. So with all that behind us, we do have a motion and a second. Madam Secretary, would you please conduct a roll call vote?
Assemblywoman Bilbray Axelrod,
Yes.
Assemblywoman Cohen,
Yes.
Assemblywoman Gonzalez,
Yes.
Assemblywoman Hanson,
No.
Assemblywoman Hardy,
Yes.
Assemblywoman Kasama,
Yes.
Assemblywoman Krasner,
Yes.
Assemblywoman Marzola,
Yes.
Assemblyman Miller,
Yes.
Assemblywoman Wynne,
Yes.
Assemblyman O'Neill,
No.
Assemblyman Orntlicker,
Yes.
Assemblywoman Summers Armstrong,
Yes.
Assemblyman Wheeler,
No.
Chairman Yeager.
Yes, motion does carry. I think we had 3 noes. The rest were yeses, and just would advise committee members, if you do decide to change your mind before the floor vote, if you could let me know that, I would appreciate it. I will sign the floor statement on Assembly Bill 42 to Vice Chair Wynne. Let's move to Assembly Bill 59, Ms. Thornton.
Assembly Bill 59 was sponsored by this committee on behalf of the Attorney General and heard in committee on February 16th. This bill prohibits a person from selling, distributing, or offering to sell cigarettes, cigarette paper, or other tobacco products to a person under 21 years of age. There's one amendment to the bills proposed by Hillary Bunker from the Attorney General's office. This amendment clarifies in Section 2, subsection 2, that the product is being sold to an ultimate consumer in the state. It includes the term vapor products. It clarifies the identification requirements the seller or distributor must obtain from the ultimate consumer. It adds that every person making sales must certify annually to the Attorney General that it uses an independent third-party age verification service. It establishes penalties, including monetary fines, license suspension or revocation, in consideration as a deceptive trade practice if requirements are not met. Clarifies what constitutes a sale to an ultimate consumer, provides for inspections to be performed on tobacco retailers at least once every 3 years, and lastly, it repeals NRS 370.395. Thank you, Chair.
Thank you, Ms. Thornton. Any questions on Assembly Bill 59 as detailed in the work session document? Assemblywoman Kasama?
Thank you. Yeah, there's a lot of things about the bill that I like and think are good. One of the areas, and I think we discussed that earlier when we reviewed the bill, was that they took the penalties out for employees. And I think that that's important to keep in, because it's going to be hard to control a night clerk, even if you give company policies. And if they disobey those, then I think that that should still be kept in there. And that's a concern that I have. So we'll probably be yes out of committee, but we reserve the right to change the vote.
Thank you, Assemblywoman Kasama. Any other questions about Assembly Bill 59? Assemblyman Wheeler?
Mr. Chairman, not sure. I know we discussed getting rid of that C felony in here. And as you know, I'm kind of passionate about this bill. I really like it. But just can't do it with the C felony. We didn't, that, I'm looking at the amendment. I thought that maybe that pulled it out, but I don't think it did. Could legal maybe let me know?
Thank you, Assemblyman Wheeler. Unfortunately, we don't have legal with us this morning, but I think we do have Ms. Bunker or Ms. Adair, and I think that was taken out of the bill. So, Ms. Adair, did you want to address that? Or Ms.
Thank you,
Bunker?
Chair. This is Jessica Adair for the record, and you have both Hillary Bunker and I. Hillary drafted the amendment, and so she can correct me if I am wrong, but the removal of the C felony is at the very end of the amendment. So we thought that that was a great point that this committee made. We wanted to incorporate that. So that is in the amendment. And if I could just clarify, the removal of the penalties of store clerks was made in a previous bill. It was the removal of criminal penalties. There are still civil penalties for clerks. So there are still penalties for clerks who sell to underage. However, it is no longer a criminal penalty, so they will not be subject to incarceration.
Thank you very much. I can vote yes on this then.
Mm-hmm.
Thank you for the response to those concerns and questions. Any other questions? Assemblywoman Krasner?
Thank you, Chair Yeager. I was just wondering, why is this a 2/3 majority vote?
We don't have legal with us. I'm not sure it's going to be when the amendment is processed. I think we're going to have to wait and see, but I'm not sure, but I think some of the things that we took out might address that. So we'll have to see what it looks like when it's amended.
Chair,
Mr.
if
if I can comment.
I believe Hillary Bunker might be able to answer that question if it is a concern to the committee. Otherwise, we can wait for legal's official legal opinion.
Ms. Bunker, did you want to address that?
Yes, Hillary Bunker, for the record, I can answer that question. So in AB 59, it's section 5, changes the definition of other tobacco products, and there's language added in to encompass products that are derived from tobacco. And the 2/3 vote is triggered because that is going to change. Those products will then be taxed the same way that the other tobacco products are. So there was a small subset of products that are derived from tobacco that are not currently captured. And by making the change in section 5, they will be. So those will be taxed similar to all other tobacco products.
Thank you for that, Ms. Bunker. Assemblyman Wheeler, did that address your question or did you have another one? Okay, looks like Assemblyman Wheeler is okay. Any other questions on Assembly Bill 59? Okay, don't see questions, so I'll take a motion to amend and do pass.
Moved. Shannon Bilbray.
Do I have a second?
I'll second.
I have a motion from Assemblywoman Wheeler Axelrod, a second from Vice Chair Wynn. Any discussion on the motion? Assemblywoman Krasner?
Thank you, Chair. I just have some questions still in regards to the amendment that I'm going to reach out to the sponsor of the bill on. I will be voting yes to get out of committee with the right to reserve and change my vote prior to floor. Thank you.
Thank you, Assemblywoman. Assemblyman O'Neill, I think I saw you next.
Thank you, Chair. And I apologize. I'll be voting yes to get it out with and reserving my right on the floor. As you know, we had a late night in Commerce and Labor. I haven't had full time to really go into depth on these amendments. So I'll be yes to get it out of committee, but I'll reserve the right, please.
Certainly. Thank you, Assemblyman O'Neill. And I was here watching your committee. You did indeed have a late night, and I think we all have a number of those in front of us in the next week or so. So certainly understand the need to want to review the amendment. And I think obviously it'll be a little clearer once we get the amendment and actually amend the bill. So appreciate that. I think Assemblywoman Hardy has her hand up. Please go ahead.
Yes, just to be quick, I'll vote yes out of committee and also want to have further time to review the amendments that have come out. Thank you.
Thank you, Assemblywoman Hardy. Assemblyman Wheeler?
Ditto.
Thank you. Any other comments?
Ditto.
That was from Assemblywoman Kasama. We have a ditto. Okay, and again, I will remind folks, Assemblywoman Hanson, did you want to say something as well? I think you're muted still because it's April Fool's Day.
You're gonna wish I was muted. I think I'm the rogue no. So just, I think I'd already notified, so thank you.
Yeah, no problem. And just as a reminder to committee members, you certainly always have the right to change your vote on the floor. Just if you let me know, that's helpful so we can have an idea how things are going to happen on the floor. So I think that's all the discussion. Madam Secretary, we have a motion and a second. Could you please conduct a roll call vote?
Assemblywoman Bilbray Axelrod,
Yes.
Assemblywoman Cohen,
Yes.
Assemblywoman Gonzalez,
Yes.
Assemblywoman Hanson,
No,
Assemblywoman Hardy,
Yes.
Assemblywoman Kasama,
Yes.
Assemblywoman Krasner,
Yes.
Assemblywoman Marzola,
Yes.
Assemblyman Miller,
Yes.
Assemblywoman Wynne,
Yes.
Assemblyman O'Neill,
Yes, with the reservation.
Assemblyman Orentlicker,
Yes.
Assemblywoman Summers Armstrong,
Yes.
Assemblyman Wheeler,
Maybe. I mean, yes.
Chairman Yeager.
Yes, we do. The motion does carry. We had one no. I will assign the floor statement on that one to Assemblyman Wheeler because I know how much he cares about this bill. So thank you, Assemblyman Wheeler.
Don't do that if I have to vote no on the floor.
Yeah, if you change your mind and you want to vote no, just let me know. We'll reassign the floor statement. Ms. Thornton, could we go to Assembly Bill 125 next?
Assembly Bill 125 was sponsored by Assemblywoman Duran and heard in committee on February 24th. This bill deletes the restriction for an offender who has been convicted of a Category B felony to earn credits to reduce his or her sentence of imprisonment, which must be deducted from the maximum term or the maximum aggregate term imposed by a sentence. These changes are retroactive for offenders who are committed offenses before October 1st, 2021. There's one amendment proposed by Assemblywoman Duran, and this amendment does the following. First, provides that the bill applies to offenders who committed an offense after July 1st, 2007, and have not been convicted of an attempt of sexual offense, vehicular homicide, residential burglary, or habitual criminal adjudication. And lastly, it deletes references to driving under the influence statutes 484C.110 and NRS 484C.120. Thank you, Chair.
Thank you, Ms. Thornton. Any questions on Assembly Bill 125 as detailed in the work session document? I don't see questions. We'll have time for discussion, of course, but for now, I take a motion to amend and do pass.
And move to amend and do pass.
Who'd like to second?
Vice Chair Wynn. Sorry.
I'll second.
I have a motion from Vice Chair Wynn, a second from Assemblyman Miller. Discussion on the motion? Assemblywoman Hanson?
Thank you, Chair. I've been wrestling with this one. I support this, the intent and the concept. I'm not quite there yet. And so I tend to do the opposite. I'm going to be no, and then get me to yes. So, but I appreciate the intent, appreciate the work that's been done, and hoping we can do more before it goes to the floor, but no for now.
Thank you, Assemblywoman Hanson. Further discussion? Assemblywoman Summers Armstrong?
Thank you, Chair Yeager. I'm reading the proposed amendment that is from on Assemblywoman Duran's letterhead, and I'm not sure that I saw this last night. Am I missing something? Her amendment says July 1, 2007. Offenses after July 1, 2007, but on the letterhead, it says 1997.
Can I clarify for that?
Thank you.
Yes, please. Please.
Thank you. Part of that amendment came into play when we met with the Attorney General's office as well as NDOC. I think our intent was to just include language that had occurred, I believe, in 2007 to allow this same type of credit on nonviolent C, D, and E felonies. And so we thought we'll just put B in there. Well, it turns out that the Attorney General's office, there was unclarity, and we've never corrected or clarified the law as to when the applicable date happened. And so they deal with hundreds of what are called post-conviction writ of habeas corpus, like petitions that are like a pseudo-civil criminal thing. And so putting clarity on that date allowed, it clarified in law something that probably should have been done in 2007, and it's never been brought to the attention. So we were able to make it in there so it's very clear that if you are in custody on a non-violent B felony, that you qualify for that good time credit from that date forward, because the people before that date actually are under a different structure where they actually get way more credit. So they didn't want to go back and take away credit from people pre-1997, if that makes sense.
Thank you, Chair Yeager. If I might follow up with the Vice Chair.
Please.
So, Vice Chair, so is the 1997 date going to stay to capture those folks? And then there is a specification that this particular change and the enumeration of the number of hours that people can accumulate to go against their sentence only applies to people post July 1, 2007. Is that what you're saying, ma'am?
If you were sentenced before that date of 1997, it's 1997, yeah, then you're under a completely different credit structure. In fact, they get way more credit. So they're under a completely different credit structure. This is like moving forward after like cases from that date forward. And we did that just to give clarity to the Attorney General's office. They apparently have been under this horrible like gray area, and this gives them and it will give the courts a lot of clarity. Unfortunately, it sounds like it's never been brought up until we opened it up with this potential bill.
Thank you.
Assemblywoman Kasama.
Okay, now I'm confused. Thank you, Chair. So question to Vice Chair Nguyen, but the amendment says after July 1st, 2007. So I think that's what Assemblywoman Chandra Armstrong was talking about.
I'm trying to decide if there's anyone still here from the AG's office on the call.
Because it sounds like we have two dates, and are we using both dates or just one date? Because the amendment says July 1st, 2007.
There's two dates. So there's like dates from this time to this time that are under like a previous like sentence structure, and then there are people after that 2007 date forward.
So we want both dates. We want both dates in there.
We want both dates in there. Yeah.
Thank you. Thank you.
It's a very, very technical thing that I'll be honest with you. I did not realize it was a problem. When we got in there and we realized, I know that the Attorney General's office, they have like 3 people that are super dedicated and receive probably hundreds, if not thousands a year petitions from people that are incarcerated for various things, a lot of them having to do with their sentences and credit determinations. At NDOC, I think we have like one person that does all of the credit determinations. And so this was really meant to clarify in law to hopefully be able to make it a lot easier for them to respond to these petitions. Unfortunately, I think people are going to continue to file these petitions, but this does make it so much easier for them to kind of address and concretely say, this doesn't apply to you or this does apply to you. And I see Attorney General Ford on here, and I think he could probably confirm that as well. Although I know he wasn't, he has a whole team that does this.
Attorney General Ford,
May I be
please.
recognized? Yeah, thank you
Please.
so much. I cannot answer the question directly, but what I can offer is an immediate reach out to Heather Proctor, who runs this division in my office, and I can have her jump on if I can catch up with her, Madam Vice Chair, if that's okay. If you need additional answers to these questions.
If she does, and I will tell you that I know that Assemblywoman Duran is continuing to have conversations about Assembly Bill 125 to see if we can tighten it up even further. But the amendment was meant to aid the Attorney General's office in, honestly, sometimes what are frivolous, like petitions that are being filed on a pro per basis by people that are incarcerated. And it's because it's unclear in the law. And so it does take up a lot of their time. But if it's up to you, Chair, whether or not the members that answered their questions or.
Yeah, so let me just ask, members, are members comfortable voting on the bill as with the record that we've made, or would people like to hear from Ms. Proctor first? I guess maybe let me ask it this way. If you'd like to hear from Ms. Proctor before taking the vote on the bill, just raise your hand in front of your camera so I can see that. Okay, we do have a couple of them. So maybe what I'll do is, I don't know, Attorney General Ford, if she's able to jump on, but for now, maybe I'll just ask that we.
She's on the phone. She's holding on the phone.
Oh, perfect. Are we able to get BPS? Are we able to get Ms. Proctor? Do we know what number she may be calling in on?
Chair Yeager, this is broadcast. A question for Attorney General Ford. Do you know if she's in our public comment line? She is not on our current.
So I have her on, I think, the public comment line with the last three digits of 267, if my information is accurate.
Chair Yeager, let me check on that quickly, and I will be back as soon as I can.
And she will do a much better job. She's much more eloquent about explaining the difference. It's a very technical change.
Chair Yeager, we do have her in the public comment line, and we will get her on momentarily.
Thank you.
Thank you, Mr. Chair. I will mute myself and stop my video. If you need me, I'm still here.
Thank you, Attorney General.
Thank you, Chair. This is Judy in public comment. Would the caller with the last three digits of 267 please hit *6 to unmute yourself and begin to speak? Caller with the last three digits of 267, begin to speak.
She will do a much better job. She's much more eloquent about explaining the difference.
This is Heather Proctor with the Attorney General's office.
Hi, Ms. Proctor. I'm not sure if you've been following the discussions, but there were just some questions from committee members about the amendment on Assembly Bill 125 and the reference to that date of, I think it was July 1, 2007, and we're hoping you could give some clarity on what the issue was there.
Certainly. So subsection 8 was adopted pursuant to AB 510 back in 2007, and therefore the restrictions that apply through subsection 8 only apply to inmates who committed their crimes on or after July 1st, 2007. Unfortunately, there has been some confusion on that because that enactment date only appears in the actual bill. It does not appear in the statute itself. And so who it applies to has been extremely confusing for the courts, for the inmates, and for counsel alike. So that is why we have added that date. The amendment and the changes to that would only apply retroactive to 2007 rather than 1997 regarding Category B felonies.
Thank you, Ms. Proctor. And so I could just perhaps make sure I understand. There was a prior bill passed in the legislature, and it only applied to offenders who were sentenced after July 1st of 2007, but it seems like that reference to the date was not included in statute. So there's been a lot of litigation, and what this amendment does is pretty clearly puts that in statute. So hopefully you won't have to respond to all this litigation about whether or not people get credit relating to a prior bill that the legislature passed.
That is correct. One small change, it is for inmates who committed their crimes on or after July 2007 rather than when they were sentenced.
Thank you, Ms. Proctor. Appreciate that. Ms. Krasner, did you have a question?
Yes, thank you, Chair Yeager. I did have a question. So I appreciate the intent of the bill. I'm wondering, why are we expanding these credits to persons who committed B felonies? B felonies are very serious. Thank you.
Well, Assemblywoman Krasner, I think that was discussed in the hearing on the bill. I don't think the amendment really just limits who gets the credit. So I'd have to just ask you to sort of rely on your memory of the actual presentation of the bill, because that's what the original bill did, was expanded it to certain nonviolent category Bs. So I don't want to relitigate the merits of the policy discussion in the work session. So I would just ask you to vote accordingly, however you would like, but I think we did discuss that quite a bit in the actual hearing on Assembly Bill 125. While we have Ms. Proctor on the phone, any other questions about this July 1, 2007 amendment? Okay, I don't think so. Ms. Proctor, thank you for joining us by telephone. We appreciate that clarification. Before we take a vote, any further discussion on the bill? Okay, I think it is. Assemblyman O'Neill, you want to say something, please?
Yeah, I appreciate the time. I just got to chime in that, I like the intent of the bill, and I don't think we're there yet. I think there still needs to be a little more adjustment to it. So I think I'll go along with Ms. Hanson's comment first of I'll vote no, and I'll have to work to get to yes.
Thank you, Assemblyman O'Neill. Further discussion? Okay, before anyone else says anything, Madam Secretary, please do a roll call vote, please.
Assemblywoman Bilbray Axelrod,
Yes.
Assemblywoman Cohen,
Yes.
Assemblywoman Gonzalez,
Yes.
Assemblywoman Hanson, Assemblywoman Hardy,
No.
Assemblywoman Kasama,
Yes.
Assemblywoman Krasner,
No.
Assemblywoman Marzola,
Yes.
Assemblyman Miller,
Yes.
Assemblywoman Wynne,
Yes.
Assemblyman O'Neill,
No.
Assemblyman Orentlicker,
Yes.
Assemblywoman Summers Armstrong,
Yes.
Assemblyman Wheeler,
No.
Chairman Yeager.
Yes, and I did just want to ask, I didn't hear a response from Assemblywoman Hanson. I believe she said she was a no, but just wanted to confirm that for the record. Okay, she has indicated she is a no, so the motion does carry. We had 5 no's. I'm going to assign the floor statement to Assemblywoman Duran, but we'll list Vice Chair Wynne as a backup in case there are questions on the measure once it gets amended and reaches the floor. Ms. Thornton, could we go to Assembly Bill 219, please?
Assembly Bill 219 was sponsored by Assemblyman Yeager and heard in this committee on March 12th. This bill revises provisions governing the sealing of criminal records. There are 2 amendments to this bill. The first amendment amends the bill to clarify that nothing in the bill prohibits prosecuting attorneys from stipulating to the sealing of records by doing the following. It revises certain sections to clarify that if the prosecuting attorney does not stipulate to the sealing of records or does not file an objection within 30 days and the court makes a finding, the court is required to seal the records. A hearing must be conducted if an objection is filed, and if no objecting party attends the hearing, the court must seal the records. It also revises Section 6 to provide that a person whose petition is denied may file an appeal. And the second amendment includes additional sponsors to the bill. Thank you, Chair.
Thank you, Ms. Thornton, and want to thank Bailey Bordelin, who's on the Zoom with us as well, for all of her work in getting everyone to what I think is a good place on this bill. Any questions about Assembly Bill 219 as detailed on the work session document? I don't see questions. Would take a motion to amend and do pass.
I'll amend and do pass.
I'll second that.
So I have a motion from Assemblyman O'Neill, a second from Vice Chair Wynn. Any discussion on the motion? Seeing no discussion, Madam Secretary, would you please conduct a roll call vote?
Assemblywoman Bilbray Axelrod,
Yes.
Assemblywoman Cohen,
Yes.
Assemblywoman Gonzalez,
Yes.
Assemblywoman Hanson,
Yes.
Assemblywoman Hardy,
Yes.
Assemblywoman Kasama,
Yes.
Assemblywoman Krasner,
Yes.
Assemblywoman Marzola,
Yes.
Assemblyman Miller,
Yes.
Assemblywoman Wynn,
Yes.
Assemblyman O'Neill,
Yes.
Assemblyman Orentlicker,
Yes.
Assemblywoman Summers Armstrong,
Yes.
Assemblyman Wheeler,
Yes.
Chairman Yeager.
Yes, motion carries. It is unanimous. I will take the floor statement on that one. And again, thank you for your work, Ms. Bordelin. Let's go next to Assembly Bill 230, please. Ms. Thornton.
Assembly Bill 230 was sponsored by Assemblyman Miller and heard in committee on March 18th. This bill provides that the juvenile court has exclusive jurisdiction over a child who's alleged to have committed an act designated as a delinquent by removing certain exclusions from the jurisdiction of the juvenile court. There's an amendment to the bill sponsored by Assemblyman Miller. The First Amendment does the following. It retains language in the bill regarding a person who is excluded from the jurisdiction of the juvenile court. Retains language regarding certain acts that the juvenile court does not have jurisdiction over, including murder, attempted murder, a felony resulting in death or substantial bodily harm to the victim under certain circumstances, and a category A or B felony if the person was at least 16 but less than 18 years of age. It also requires the Legislative Committee on Child Welfare and Juvenile Justice to conduct a study during the 2021 and 2022 interim concerning the infrastructure needs and costs associated with housing youth awaiting a juvenile certification proceeding in the state. And the Second Amendment adds additional sponsors to the bill. Thank you, Chair.
Thank you, Ms. Thornton. And I will note, I wanted to be added as a sponsor as well, and I neglected to convey that to Assemblyman Miller. So when we get to a motion, I would just ask that we include that as well. Any questions on Assembly Bill 230 as detailed in the work session document? Assemblywoman Bilber Axelrod, did you have a question?
I was just hoping that I could be added to, I don't, maybe I'm missing my, maybe I'm looking at the one. I thought I had asked to.
You may have asked to. We just may not have included everyone on the amendment, so I'll add that as well.
Actually, Chair, Assemblywoman Bilbray Axelrod is was already a sponsor from the beginning.
Sorry.
Thank you.
It's that time of session. No worries. Assemblywoman Summers Armstrong.
I would also like to be added. Thank you.
Assemblyman Miller, is Assemblywoman Summers Armstrong already a sponsor?
She is already a sponsor. At this point, I believe every member of the committee is a sponsor. If someone is not a sponsor, well, I guess that's what we're doing right now. People are like, I'm not sure, but I believe I have everyone on the committee. And just thank you all for jumping on board with this.
Thank you, Assemblyman Miller. Any other questions? Okay, I don't see questions. So I'll take a motion to amend and do pass with that one addition that I'll be added as a sponsor as
I'll
well.
move to amend and do pass with that amendment.
Second.
So motion from Vice Chair Wynn, a second from Assemblywoman Summers Armstrong. Any discussion on the motion? Assemblywoman Hanson.
Thank you, Chair. And I just want to congratulate Assemblyman Miller on, I think this is to move through, and so appreciative of the work he's done as a member of the Interim Child Welfare and Juvenile Justice Committee. This has been an issue, and
so happy to be able to support this legislation and for the work that he has done as a freshman working this through and working with stakeholders. Very much appreciated and congratulations.
Thank you, Assemblywoman Hanson. Any other discussion? I don't see any further discussion. Madam Secretary, roll call vote, please.
Assemblywoman Bilbray Axelrod,
Yes.
Assemblywoman Cohen,
Yes.
Assemblywoman Gonzalez,
Yes.
Assemblywoman Hanson,
Yes.
Assemblywoman Hardy,
Yes.
Assemblywoman Kasama,
Yes.
Assemblywoman Krasner,
Yes.
Assemblywoman Marzola, Assemblyman Miller,
Yes.
Assemblywoman Wynne,
Yes.
Assemblyman O'Neill,
Yes.
Assemblyman Orentlicker,
Yes.
Assemblywoman Summers Armstrong,
Yes.
Assemblyman Wheeler,
Yes.
Chairman Yeager.
Yes, and I didn't hear a response from Assemblywoman Marzola, but give me a thumbs up if you were a yes, and I do see.
I did say yes.
Oh, okay, thank you. I did not hear it, but I'm getting older, so my hearing is not as good as it used to be. So that is unanimous. The motion does carry. I will assign the floor statement, of course, to Assemblyman Miller, and congratulations. Let's go next to Assembly Bill 284. Ms. Thornton.
Assembly Bill 284 was sponsored by Assemblywoman Martinez and heard in committee on March 22nd. This bill establishes a procedure for a person to contest the validity of a lien on a motor vehicle. There are two amendments to the bill. The first amendment was sponsored by the Nevada Trucking Association and tow operators of Northern Nevada. And this bill excludes tow cars holding a certificate of public convenience and necessity issued pursuant to NRS 706.4463. And secondly, Assemblywoman Cohen proposed an amendment to clarify the days in the bill as calendar days. Thank you, Chair.
Thank you, Ms. Thornton. Any questions on Assembly Bill 284? Seeing no questions, I'll take a motion to amend and do pass.
And move to amend and do pass.
Do we have a second? So we have a second from, is that a second, Assemblyman Wheeler? So we have a motion from Vice Chair Wynn, a second from Assemblyman Wheeler. Any discussion on the motion? Seeing no discussion, roll call vote, please. Madam Secretary.
Assemblywoman Bilbray Axelrod,
Yes.
Assemblywoman Cohen,
Yes.
Assemblywoman Gonzalez,
Yes.
Assemblywoman Hanson,
Yes.
Assemblywoman Hardy,
Yes.
Assemblywoman Kasama,
Yes.
Assemblywoman Krasner,
Yes.
Assemblywoman Marzola,
Yes.
Assemblyman Miller,
Yes.
Assemblywoman Wynne,
Yes.
Assemblyman O'Neill,
Yes.
Assemblyman Orentlicker,
Yes.
Assemblywoman Summers Armstrong,
Yes.
Assemblyman Wheeler,
Yes.
Chairman Yeager.
Yes, motion does carry unanimously. I will assign the floor statement to Assemblywoman Martinez, and I'll be the backup just in case we need one. Committee, we're almost there. We just have a few more. Ms. Thornton, could we go to Assembly Bill 318, please?
Assembly Bill 318 was sponsored by Assemblywoman Marzola and heard in committee on March 23rd. This bill clarifies various provisions relating to trusts and estates. There are two amendments to this measure. The first one was sponsored by Mark Noble and Alan Freer from the Legislative Committee of the Probate and Trust section of the State Bar of Nevada. It first revises certain provisions dealing with the independent administration of estates. It revises language to clarify and make consistent that it is the exercise of the trustee's discretion to make the tax payment. It adds clarifying language regarding the distribution of property to the second trust. Changes may to shall in section 41 regarding the mailing of a copy of a notice to an additional creditor. It adds a new section amending NRS 139.100 to provide notice provisions on the initial hearing petitions to the public administrator in situations where the petitioner seeking appointment is neither a spouse or heir nor a nominee of the spouse or heir in order to prevent potential abuse. It adds a new section to NRS 143.350 to permit the probate court discretion when granting independent administration of estates. And it amends a new section of NRS 143.380 to afford heirs or beneficiaries of the estate additional safeguard by requiring their express written consent where a personal representative seeks a non-court sale of property for less than 90% of the value of its appraised value. The Second Amendment was sponsored by Assemblywoman Cohen, and this replaces the business days with calendar days throughout the amendment. Thank you, Chair.
Thank you, Ms. Thornton. Any questions on Assembly Bill 318 as detailed in the work session document? I was wondering if anyone wanted to rehear this one. Remember, it was a long, complex hearing. So seeing no discussion, I'll take a motion to amend and do pass.
I'll move to amend and do pass.
You have a second?
I'll second.
So a motion from Vice Chair Wynn, a second from Assemblyman O'Neill. Any discussion on the motion? I don't see any discussion. Madam Secretary, roll call vote, please.
Assemblywoman Bilbray Axelrod. Assemblywoman Cohen. Assemblywoman Gonzalez.
Yes.
Assemblywoman Hanson.
Yes.
Assemblywoman Hardy.
Yes.
Assemblywoman Kasama.
Yes.
Assemblywoman Krasner.
Yes.
Assemblywoman Marzola.
Yes.
Assemblyman Miller.
Yes.
Assemblywoman Wynn.
Yes.
Assemblyman O'Neill.
Yes.
Assemblyman Orentlicker.
Yes.
Assemblywoman Summers Armstrong.
Yes.
Assemblyman Wheeler.
Yes.
Chairman Yeager.
Yes, motion does carry unanimously. I will, of course, give that floor statement to Assemblywoman Marzola. Congratulations. And we will move on to, remember, we are pulling Assembly Bill 339, so we're not going to work session that today, but we'll move at this time to Assembly Bill 393.
Thank you, Chair. Assembly Bill 393 makes various changes relating to criminal justice, sponsored by this committee and heard on March 30th. There's one amendment to the bill sponsored by Tom Lawson, Chief Division of Parole and Probation. This amendment revises provisions governing a sex offender's petition for release from lifetime supervision to provide that a licensed clinical professional who has received training in the treatment of sex offenders may perform the evaluation. And it strikes the language court or in Section 21, as revocations will be heard only by the State Board of Pardons Commissioners and not the court. Thank you, Chair.
Thank you, Ms. Thornton. Any questions on Assembly Bill 393 as detailed in the work session document? I don't see questions. I'll take a motion to amend and do pass.
So
I'll move
moved.
to amend and do pass. Ooh.
That was a close one. I'm going to give that one to Vice Chair Wynn, but I'll give the second to Assemblyman Wheeler. Any discussion on the motion? Seeing no discussion, Madam Secretary, would you please conduct a roll call vote?
Assemblywoman Bilbray Axelrod.
Yes.
Assemblywoman Cohen.
Yes.
Assemblywoman Gonzalez.
Yes.
Assemblywoman Hanson.
Yes.
Assemblywoman Hardy.
Yes.
Assemblywoman Kasama.
Yes.
Assemblywoman Krasner.
Yes.
Assemblywoman Marzola.
Yes.
Assemblyman Miller,
Yes.
Assemblywoman Wynn,
Yes.
Assemblyman O'Neill,
Yes.
Assemblyman Orentlicker,
Yes.
Assemblywoman Summers Armstrong,
Yes.
Assemblyman Wheeler,
Yes.
Chairman Yeager.
Yes, motion does carry unanimously. I will assign the floor statement to Vice Chair Wynn. And our last bill on the work session this morning is Assembly Bill 401. Ms. Thornton?
All right. Apologies. Assembly Bill 401 directs the Advisory Commission on the Administration of Justice to appoint a subcommittee to study records of criminal history, sponsored by this committee and heard on March 30th. There's one amendment to this bill, sponsored by Assemblywoman Wynn, and this amendment rises the bill by directing the Legislative Commission to appoint an interim committee to study the sealing or expungement of criminal records instead of the Advisory Commission on the Administration of Justice appointing a subcommittee. Thank you, Chair.
Thank you, Ms. Thornton. Any questions on Assembly Bill 401? I don't see questions. I'll take a motion to amend and do pass.
I'll make a motion to amend and do pass.
I'll second.
Motion from Vice Chair Wynn, second from Assemblywoman Krasner. Any discussion on the motion? Seeing no discussion, Madam Secretary, please conduct a roll call vote.
Assemblywoman Bilbray Axelrod,
Yes.
Assemblywoman Cohen,
Yes.
Assemblywoman Gonzalez,
Yes.
Assemblywoman Hanson,
Yes.
Assemblywoman Hardy,
Yes.
Assemblywoman Kasama,
Yes.
Assemblywoman Krasner,
Yes.
Assemblywoman Marzola,
Yes.
Assemblyman Miller,
Yes.
Assemblywoman Wynn,
Yes.
Assemblyman O'Neill,
Yes.
Assemblyman Orentlicker,
Yes.
Assemblywoman Summers Armstrong,
Yes.
Assemblyman Wheeler,
Yes.
Chairman Yeager.
Yes, motion does carry unanimously, and I will assign the floor statement to Assemblywoman Krasner on Assembly Bill 401. Okay, committee, thank you. That takes us through the work session. We're now going to move on to our agenda, the rest of our agenda. As you can see, we have 3 bills, and I think we'll be able to get through these in hopefully a timely fashion. So at this time, I'm going to open the hearing on Assembly Bill 403. Assembly Bill 403 revises provisions governing certain crimes. I believe we have our own Assemblywoman Brown May with us on the Zoom, and Mr. Pirro is joining her as well. So welcome to the Assembly Judiciary Committee this morning. We'll give you a chance to present the bill, and then I'm sure we'll have some questions for you. So please proceed when you're ready.
Thank you. Thank you, Chair Yeager, Vice Chair Wynn, members of the Judiciary Committee. I am very pleased and excited to be in front of this committee this morning, especially to present Assembly Bill 403. For the record, my name is Tracy Brown May, and I represent Assembly District 42. As a mom, a dog walker, a runner, and a cyclist, I spend a significant amount of time as a pedestrian on my local streets. Many of my neighbors cross mid-street to say hello and greet each other. Nevada revised statutes identify this action as criminal. Miss Ida can be cited for a criminal violation for crossing the street outside of a marked crosswalk. This is troubling. Often, marked crosswalks are more than a half a mile away. This bill, as presented, decriminalizes certain violations by pedestrians, most commonly referred to as jaywalking. While crossing the street outside of a marked crosswalk may be a safety hazard and should be deterred when safety is at risk, a criminal charge for violating this statute is unnecessary and excessive. So here's a little background information. Nevada's current law criminalizes jaywalking as a misdemeanor, which is punishable by imprisonment in the county jail for not more than 6 months, or by a fine of not more than $1,000, or both the fine and imprisonment. this bill would decriminalize jaywalking. So it's important to note that this bill does not eliminate penalties or citations for jaywalking. It does instead direct the courts to consider this citation as a civil infraction, not a criminal infraction. Chair, with your permission, I'd like to introduce my co-presenter, John Pirro, the Chief Deputy Public Defender with the Clark County Public Defender's Office. And Mr. Pirro will walk us through the sections of this bill and then be available to answer questions.
Thank you so much, Assemblywoman. It's great to have you here in Judiciary Committee this morning. Appreciate your comments and your work on this bill. Mr. Pirro, welcome back to Assembly Judiciary, and please go ahead.
Thank you, Mr. Chairman and members of the committee. John Pirro from the Clark County Public Defender's Office. This is a short bill, but it's a good bill. Section 1 eliminates jaywalking from, frankly, what looks like a weird place to have jaywalking for a consecutive penalty. Jaywalking was listed in Section 1 in a pedestrian safety zone, which is weird because that's where people would walk anyways. So we're eliminating it there. And then if you go to Section 2, it just clearly states at the very bottom that it's making it a civil infraction, punishable by a $100 fine and not a misdemeanor criminal offense that doctors would have to report on their applications when they're trying to get residency places or get into medical school. There are some things I did want to let you know, and my friend Roger Farr, who's going to testify on the phone lines in support, runs a web scraping program that picks up the numbers of people arrested for pedestrian offenses when they're easily findable. And just to let the committee know, as of this month or yesterday, there were 199 people arrested and jailed for 1.5 days on just jaywalking or a pedestrian offense alone, just that. And at a cost of $190 a day plus half of that rate, that comes out to about $56,715 that we have paid to jail somebody on just a jaywalking offense. However, just the Las Vegas Municipal Court alone, because we can't find out the county's numbers, has 4,515 outstanding warrants for pedestrian offenses alone. If all of those people get arrested and jailed for just 1 day to deal with this jaywalking offense, that will amount to $898,485. And that's just freeze framing jaywalking arrests and jailing just till March 31st. That's not talking about any other arrests that will happen the rest of the year. That's how much we as taxpayers will pay. So this is a short bill that has a big impact that is both smart criminal justice policy-wise as well as fiscally responsible. Thank you, Chair.
Thank you, Mr. Pirro. Assemblywoman Brown-May, is there anybody else as part of your presentation, or would you like to take questions at this time?
We would prefer to entertain questions at this point. We do have Attorney General, I believe, on the phone, who is here to offer his support when we get to that part of the meeting. But right now, Mr. Pirro and I are the presentation. Thank you.
Thank you so much, and certainly appreciate the brevity of the presentation given how much work we have left to do in the committee yet today and until the end of next week. So committee members, now would be the time for questions. Who has a question? We'll start with Vice Chair Wynn.
Thank you for bringing this bill. I think this is a long time coming, and I know that it has been used for decades to stop people to investigate other crimes. When you're talking about these 190, I believe you said 199 people, is that correct, Mr. Pirro?
John Pirro for the record. Yes, Assemblywoman. 199 people just on traffic offenses alone, just jaywalking by itself have been jailed. That's
and
not
so
counting.
You're not counting like someone who was stopped for jaywalking and then later arrested for some other offense. That's just solely jaywalking.
Just solely jaywalking.
Thank you. That was my question.
Thank you, Vice Chair Wynn. I saw Assemblywoman Hanson raised her hand. Please go ahead.
Thank you, Chair. And thank you for being here today, Assemblywoman Brown-May. And appreciate the bill on the surface. It does seem like Mr. Pirro said weird, and I'm all for getting rid of weird in the statutes. But I just, to follow up to what Vice Chair Wynn was the data, the 199 just for jaywalking.
two things. I'm assuming a lot of that is probably along the Las Vegas Strip. Do we have kind of an idea of where the majority of that 199 were?
John Peel, for the record, I do not have that data. I'm sorry. We just pull from the jails numbers. I wish that would be a question more appropriate for Mr. Calloway, but I will say that the Strip has done a good job of making pedestrian safe zones so that jaywalking is not, people have our pedestrian bridges that they use, so jaywalking is not something that happens as frequently on the Strip.
Okay, and then if I could follow up, Chair.
Please go ahead.
The other stat was, I want to make sure I wrote it down right. 4,500 outstanding warrants due to jaywalking that have
John Piro, for the record, 4,415 just in the Las Vegas Municipal Court alone, Assemblywoman Hanson. That's not counting North Las Vegas Municipal Court, Henderson Municipal Court, Las Vegas Justice Court, North Las Vegas Justice Court, or Henderson Justice Court. That's just Las Vegas Municipal Court alone. So that number that I cited to you, that if they all went to jail for just one day, which does not happen in Las Vegas Municipal Court, because if you get arrested on a Thursday, Assemblywoman Hanson, you're not going to see a judge till Monday. So I'm just giving you a baseline, one day given to the most generous number possible. That for one municipality is going to cost us $898,485 for the year if we just freeze frame it right now.
Wow. And then here's a monkey wrench. So a person, especially maybe for you, Mr. Piro, since you are in the practice of defense, a person jaywalks and a driver hits them, let's say after this law passes. There's jaywalking, but it's not jaywalking anymore. There's no there's no crosswalk. A driver hits, but it's not really the driver's fault. It's very immediate. They dash out. Are we now giving some immunity to the jaywalker's responsibility, and all the onus is on the driver now, even when it's irresponsible, because they're now given the okay to do it outside of a crosswalk?
John Piro, for the record, they're not given the okay. It's just a civil penalty. So we're not going to criminalize them for it. We're not going to make them a misdemeanor for it. So it's still not okay. You can still be cited for it. It's still a civil infraction. But instead of a potential $1,000 fine and time in jail, it's just that. And then that would be an issue litigated in the civil realm, which probably the NJA could speak to better than I could.
Thank you.
Just so I could jump in there too, I think Mr. Piro is right about that. It would still be a violation of our laws, so that would be something that would be taken into account if there was litigation about who was at fault for the traffic accident. And so then I wanted to just clarify, probably for you, Mr. Piro, we're saying it's not a criminal offense, but an officer would still be able to, stop somebody and sort of get them to a safe position if they sort of happen to be out in the road and that kind of thing. We're just saying the person can't be arrested for jaywalking unless there's some other circumstance. Do I have that correct in terms of what the bill's trying to do?
John Piro, yes.
Thank you, Mr. Piro. Are there additional questions for our presenters? Okay, I see a couple. Let's go to Assemblyman Orentlicker and then Assemblywoman Hardy.
Thank you, Chair Yeager. I'm interested in, thank you for doing this bill first. It's a very important step. Second, at the end of section 2, where subsection 2B, where it says it's punishable by the imposition of a civil penalty of $100, as opposed to, it could say is punishable by the imposition of a civil penalty of up to $100. Does this mean automatically if the jaywalker is cited, whether they're poor or wealthy, it's going to be a $100 fine? And so I'm wondering if that's the case. I'm worried about the disparities that we're going to see, because 100 is pretty stiff for somebody that is living below the poverty line.
John Piro, for the record, obviously it would be the Assemblywoman's call to make it up to $100. I think that's a reasonable request, Assemblyman Ornlicker. I also would say that people are always available to do community service if they couldn't afford the fine.
Thank you, Assemblywoman Brown-May, for the record. We're certainly happy to discuss that with you, Assemblyman Ornlicker, as we look to move this bill forward. Thank you for bringing that up.
Assemblywoman Hardy.
Thank you, Chair, and thank you for this bill. I think it is goes a little far, charging someone with a misdemeanor for crossing the street. So, in regards to the outstanding warrant cases that you mentioned, this legislation passes, would that have any effect on those outstanding warrants?
John Pirro, for the record, perhaps we could work with the court system as it is and see what we could do there. But that would probably be a question that they can answer. But that is an excellent suggestion. And we have the Criminal Justice Coordinating Council down south. And so perhaps that's a topic I could bring up with them and hopefully get the court administrators on board to do that.
Okay, great, thank you.
Do we have additional questions from committee members? Going once. Assemblywoman Summers Armstrong.
I don't have a question, Chair, and thank you for acknowledging me, Chandra Summers Armstrong, Assembly District 6, for the record. I'm really happy to see this. We see a lot of jaywalking tickets and arrests in our community, and we are just grateful to see this brought forward. Thank you, Assemblywoman Brown-May, and thank you, Mr. Pirro.
Thank you, Assemblywoman. Additional questions? Okay, I don't see additional questions. So Assemblywoman Brown-May, Mr. Pirro, thank you for presenting. We'll ask you to sit tight for just a moment while we take some testimony on the bill. At this time, I'll open it up for testimony in support of Assembly Bill 403. We do have Attorney General Ford joining us on the Zoom this morning. Welcome back to the Assembly Judiciary Committee, and please go ahead.
Thank you so much. Good morning, Chairman Yeager and members of the committee. For the record, my name is Aaron Ford, and I am your Attorney General. It's a privilege to testify today here in support of AB 403. I don't intend to duplicate the testimony of the presenters who have spoken before me today, but I do want to emphasize how regressive current laws criminalizing jaywalking really are. Although jaywalking is the misdemeanor crime on par with a traffic citation, it is on occasion the starting point of a more prolonged series of interactions with the criminal justice system. Because jaywalking is a criminal offense, failure to pay its associated fine can eventually lead to a warrant for arrest or even incarceration. Let me be clear. I'm fully aware of the safety concerns that necessitate deeming jaywalking a prohibited act. For the reasons that underpin this policy, I agree that it should continue to be a prohibited act. But the appropriate penalty for improperly crossing the street should not be the possibility of incarceration. The deterrent effect of citations lies more in the impact on the wallet than possible imprisonment. At the time of a citation being issued, the possibility of incarceration is so remote that it fails to even have a deterrent effect. It's also those least able to afford the fine, who we've heard from Assemblyman Ornlicker to say, who run the risk of incarceration. In other words, the criminalization of jaywalking with the associated possibility of incarceration creates a de facto debtor's prison, in my estimation. It's time for Nevada to move past this regressive policy so that disproportionately affects the poor. For this reason, I support AB 403. Thank you so much.
Thank you so much for being here, Attorney General Ford, and thank you for your patience as we worked through the work session before we got to the bill. I don't think there's anybody else on the Zoom in support. If I'm wrong about that, if you could just turn your camera on and unmute and let me know you'd like to testify in support. I don't see that happening. BPS, could we go to the phone line? I believe we have at least a few individuals there who'd like to give supportive testimony this morning.
Yes, Chair. To testify in support of Assembly Bill 403, press *9 now to take your place in the queue. And we will begin with the caller with the last three digits of 850. Press *6 to unmute yourself. Slowly state and spell your name for the record, and you will have 2 minutes and may begin.
Good morning, and thank you, Chairman Yeager and members of the committee. For the record, my name is Taylor Dixon, Taylor Dixon. I'm the MSW policy intern representing the ACLU of Nevada, and we support AB 403. The criminalization of jaywalking in Nevada directly affects vulnerable populations. Those experiencing poverty and homelessness are inherently less likely to have access to their own transportation and often rely on walking or city buses. We have all experienced or seen someone rushing to make it to their bus on time as it approaches, or have had to run quickly from one side of the street to another to get somewhere important on time. For people who rely heavily on walking or public transportation to take them to one place to another, sometimes the only option to make it on time is to jaywalk or bolt across the street when no cars are approaching them. As a misdemeanor that currently carries a hefty fine, the criminalization of jaywalking creates added financial hardship for people who already cannot afford the luxury of their own vehicle and heavily rely on their ability to get to work in a timely manner. Jaywalking is also typically not something that people do with the intention of harming themselves or others or to break the law. Sometimes it is the only choice for how someone can cross the street for a long period of time. In rural Nevada, many streets are not well lit or have their own crosswalks, making it difficult to avoid a potential misdemeanor in these areas. As the ACLU of Nevada, one of our goals is to reduce police interactions as much as possible, and AB 403 supports this cause. Police interactions can be an extremely uncomfortable experience for many groups of people. If jaywalking remains a misdemeanor, vulnerable populations could be put in uncomfortable situations that could raise their anxiety for days and weeks to come, as well as take important time away from other activities that police officers could be doing. We urge you to support and pass AB 403 and to decriminalize jaywalking. Thank you for your time.
Thank you for your testimony and support, Ms. Dixon. BPS, could we take the next caller in support, please?
Yes. Would the caller with the last of 080 please slowly state and spell your name for the record? You will have 2 minutes and may begin.
Hi, Jim Hoffman, Nevada Attorneys for Criminal Justice. NACJ supports AB 403. We believe that jaywalking should be treated the same as vehicle-based traffic offenses. As you know, there's a bill to decriminalize that before the legislature. Criminalizing this sort of thing doesn't prevent it from happening or improve our ability to collect fines, and it doesn't protect public safety. It simply imposes an extra burden on the poorest Nevadans, leaving them subject to arrest warrants that impair their ability to work, pay their rent, and take care of their families. Jaywalking should be a civil offense, and so NACJ supports AB 403. Thank you.
Thank you for your testimony, Mr. Hoffman. BPS, let's take the next caller in support, please.
Thank you, Chair. Would the caller with the last 3 digits of 318 slowly state and then spell your name for the record? You will have 2 minutes and may begin.
Good morning, Chair Yeager and members of the Assembly Judiciary Committee. This is Kendra Birchie, KendraBertschy with the Washoe County Public Defender's Office. I want to thank the Assemblywoman for bringing this important bill forward, and we appreciate these efforts to decriminalize infractions, and including jaywalking specifically. We do believe that this will help prevent people from becoming part of the criminal justice system, and we appreciate this effort. Thank you.
Thank you for your testimony, Ms. Birchie. BPS, let's take the next caller, please.
We are currently taking testimony in support of Assembly Bill 403. To testify, press *9 now to take your place in the queue. Chair, there are no more callers in the queue wishing to testify in support.
BPS, could we just maybe take one more moment? I believe we had Mr. Farr on the phone who wanted to testify. I think his last 3 digits are 377. I'm not sure if he's there, but I indicate that he's registered and perhaps might be on the phone. So if we could maybe give him a minute to enter the queue.
Stand by. Caller with the last 3 digits of 377. Press *6 now to unmute yourself and begin your testimony. Chair, I have asked him to unmute and given him instructions, and I'm not getting a response.
Thank you, BPS. Well, we'll move on, and perhaps we'll try to come back to that. And if we can't get to Mr. Farr in this hearing, then we'll invite him to submit some written comments. But for now, let's go ahead and suspend testimony in support. I'll now open up testimony in opposition. I don't think we have anyone on the Zoom in opposition, but again, if I'm incorrect about that, if you could turn your camera on and let me know you'd like to speak. I don't see that happening. BPS, could we go to the phone for potential opposition testimony, please?
To testify in opposition of Assembly Bill 403, press star 9 now to take your place in the queue. Once again, to testify in opposition of Assembly Bill 403, press star 9 now to take your place in the queue. Chair, there are no callers in the queue at this time.
Thank you, BPS. I will close opposition testimony. I will now open neutral testimony. We don't have anyone on the Zoom in neutral. BPS, could we go to the phone lines to see if there's anybody there who'd like to offer neutral testimony?
Yes, Chair. And we will begin with call-in user number 1. Please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Hello, Mr. Chair, members of the committee. This is Chuck Calloway, representing the Las Vegas Metropolitan Police Department. We are here neutral on this bill. I had a conversation with the Assemblywoman, and I appreciate her reaching out. Our position on this bill is the same as the position we've had on other measures to over the years to make traffic infractions civil. We don't care if the penalty is civil on the court side after the fact, but we want officers' actions in the field to remain the same. For example, if an officer sees someone violating the law, the officer could take action the same way as always, and the courts would treat it as a civil matter on the backside. Although I'm neutral on the bill, I did want to make a few comments. Number one, to dispute the notion that jaywalking is just a very minor thing and it's often used by officers to harass people. Jaywalking, as you know, often leads to fatalities, and this year we've had 27 fatalities in our jurisdiction as of this morning. Often those fatalities involve pedestrians as part of the overall factor. Speeding and, of course, impairment are other factors, but we often see pedestrians as a factor. I would encourage the committee, when they have time, to go sit in front of DI and Maryland Parkway on an afternoon near the Boulevard Mall and watch as the bus stops and lets people off, and about 20 people run across 4 lanes of traffic to try to catch the bus on the other side as people are going 45 miles down the roadway. How dangerous that can be and how that can lead to people being injured or killed. Also, it is our policy on Metro that we issue a citation for minor offenses, including jaywalking, and a supervisor must approve an arrest. I checked with our jail just now for the month of March. According to the records section at our jail, Director Marcy McMahill, we had 0 arrests. I repeat, 0 arrests in March for jaywalking. I'm not sure where the data that Mr. Pirro presented comes from, but again, according to our records section, 0 jaywalking arrests in March of this year. So we are neutral on the offense being a civil matter, and we just hope the committee takes into account that an officer in the field needs to be able to remain or have the ability to enforce people in our roadways. Thank you, Mr. Chair.
Thank you for your testimony, Mr. Calloway. BPS, are there additional callers in the neutral position?
To testify in the neutral position on Assembly Bill 403, press star 9 now to take your place in the queue. Chair, there are no more callers in the neutral position. However, the caller with the last 3 digits of 377 has rejoined the call. What would you like me to do?
Thank you, BPS. What I'll do is I'll close neutral testimony. Let's go back to support testimony and see if indeed that is Mr. Farr and if he may be able to provide his testimony at this time.
Caller with the last 3 digits of 377, press star 9 now to take your place in the queue. Caller with the last 3 digits of 377, please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Good morning. Thank you for the trouble. My name is Roger Farr, spelled R-O-G-E-R. PHARR. I'd like to thank my Assemblywoman Tracy Brown May for bringing this bill forward. I'm a resident of Assembly District 42. I'm speaking in support of AB 403. I generated the statistics that Mr. Pirro referenced. He did a great job, so I won't repeat them again. The stat I will expand is this. So the 4,515 people with open warrants for jaywalking in Las Vegas Municipal Court represents about 8% of the total number of outstanding warrants. So there's something like, I don't have the number in front of me, but there are over 50,000 outstanding warrants. And so if the other courts have a similar percentage of outstanding warrants, that number would be tens of thousands for the state. So for those tens of thousands of people who are facing warrants for pedestrian offenses and the potential for 1,000 more that would surely face jail this year if we stay at the rate that we've been jailing people for pedestrian offenses, I urge you to support this bill and decriminalize jaywalking. Thank you.
Thank you for your testimony and support, Mr. Farr, and thank you for hanging in there and helping us through the technical part. BPS, we probably don't have anybody else in support, but out of an abundance of caution, let's just please check one more time.
To provide testimony in support of Assembly Bill 403, press star 9 now to take your place in the queue. Chair, there are no more callers in the queue in support of Assembly Bill 403.
Thank you, BPS. So I will again close supportive testimony. I think that takes us through all of our testimony on the bill. At this time, I would invite Assemblywoman Brown May and Mr. Pirro to make any concluding remarks on the bill. Assemblywoman, we'll start with you.
Thank you, Mr. Chair. It was our pleasure to present this Assembly Bill 403 for your consideration today. As you can hear from the comments, there is a number of data and opinion around the severity of this issue. We agree that crossing in an unsafe manner is something that people need to still be aware of. However, criminalizing this penalty, I think, is something that we certainly can move away from so that we're looking at it as a civil offense. We look forward to working with you, Mr. Ohrenlichter, to identify the amount of the fine, because really that's exactly what we're trying to address with this bill. I thank you for your time and your consideration today, and we urge your support for this bill.
Thank you, Assemblywoman. Mr. Pirro, any concluding remarks?
John Pirro, no, Chairman. Thank you for your time.
Great. Thank you so much to the both of you for being here and presenting the bill this morning. We certainly appreciate it, and we hope you have a great rest of the day. I will now close the hearing on Assembly Bill 403. We'll take the next bill on the agenda, which is Assembly Bill 407. So at this time, I will open the hearing on that bill. Assembly Bill 407 authorizes the issuance of an order for protection of a vulnerable adult. And before I turn it over for the hearing, I just wanted to confirm for members of the committee and members of the public, there are a couple of amendments to the bill that are included on Nellis. I believe both of those are considered friendly amendments, but we'll get confirmation from our sponsor. We have our own Assemblywoman Bilbray Axelrod to present the bill, and I think she has some backup with her as well. So we'll turn it over for the presentation, and then I'm sure we'll have some questions. So please go ahead when you're ready.
Thank you, Chair Yeager and members of the committee. For the record, I am Shannon Bilbray Axelrod, representing Assembly District 34 in Clark County. Thank you for your time considering Assembly Bill 407, which seeks to protect vulnerable adults against abuse, exploitation, and neglect. With me this morning is Jennifer M. Richards, Esquire, Chief Elder and Disabilities Rights Attorney, and Tammy Seaver, Social Services Chief, both from the Aging and Disabilities Division of the Department of Health and Human Services. Assembly Bill 407 was recommended from the Legislative Committee on Senior Citizens, Veterans, and Adults with Special Needs during the 2019-2020 interim. According to Ms. Richards' presentation on September 1st, 2020, vulnerable patients are particularly susceptible to mental and emotional abuse, abandonment, neglect, isolation, financial control, and other types of control. These are all among the concerns. All of these factors are known to be associated with increased risk of abuse. Existing law in Nevada does provide several types of protection orders under Chapter 33 of NRS. However, as Ms. Richards and Ms. Severs will further explain, the behavior and specific relationship required to seek the existing protection order is not typically present in cases of abuse and neglect and exploitation of vulnerable adults. As Chair indicated, we do have 2 friendly amendments that are listed on Nellis. In addition, there are a few fact sheets about abuse in these vulnerable populations. I encourage you to look at these staggering and heartbreaking numbers. I failed to mention that I actually served as vice chair on that interim committee, and this was probably some of the most heartbreaking testimony information that we heard during the interim. So with that, I will turn over the presentation to Ms. Richards and Ms. Severs, who will discuss further the need for AB 407 and present the sections of the bill. Thank you.
Thank you, Assemblywoman, and thank you for your service on the interim committee. We will hand it over to Ms. Richards and Ms. Seaver, who I see have joined us, and please go ahead with your presentation.
Thank you, Chair Yeager, and thank you, Assemblywoman Bilbray Axelrod, and thank you, members of the committee, for allowing us to appear this morning. I would also like to note we have with us this morning Carrie Embry, who is the Governor's Consumer Health Advocate and the former Chief of Adult Protective Services. I would like to turn it over to Ms. Seaver to begin the presentation, and then I will add some additional comments following that. Good morning. For the record, I'm Tammy Seaver, Social Services Chief for Adult Protective Services. Last session, we came before this body to expand our program to include all vulnerable adults in Nevada. As a result of that legislative change, we saw an immediate increase in our caseload that continues to rise. We are back today to add vulnerable adult protection orders to Nevada law in line with national recommendations and to provide necessary assistance to our friends, family, and neighbors that we serve across the state. Elder abuse has been referred to as a hidden epidemic in the United States, with an estimate that 1 out of every 10 people aged 60 and over are victims of caregiver neglect, financial fraud and exploitation, and/or psychological, physical, and sexual abuse every year. Persons with cognitive deficits, such as dementia, are substantially more likely to be victimized. Individuals with intellectual or developmental disabilities are 4 to 10 times more likely to be abused than their peers without disabilities. To learn more, we filed exhibits from the National Center on Elder Abuse. APS continues to see an increase in cases. So far for fiscal year 2021, open cases through February 28, 2021, Adult Protective Services has opened 5,188 cases. We are projected for fiscal year 2021 of 7,782. As of this morning, I found out for March, we opened 752 cases statewide. Fiscal year 2020, APS opened 7,421 cases, which showed an increase of 14% after our expansion to a full APS or Adult Protective Service program. In addition to empowering an individual to seek an order on their own behalf, this bill will allow Adult Protective Services to act as petitioner. For those that have significant physical, mental, or cognitive limitations, having the Adult Protective Service worker assisting the client will remove barriers to getting help. I'd like to share some actual cases that demonstrate on how these protective orders could impact the lives of Nevadans, specifically focusing on the limited cases where Adult Protective Services may have acted as petitioner. I've changed the names in the following examples to protect the identity and the privacy of the parties. First, I'd like to share John and Joy's story. Joy Smith was 91 years old, recently widowed, living with her 57-year-old intellectual disabled son, John. Her husband had previously taken care of all the bills and shopping for the three of them. After her husband's death, two neighbors befriended Mrs. Smith and John, buying groceries and assisting with bill paying. Other neighbors became concerned with the couple, started isolating both Joy and John from the community, and an Adult Protective Services report was filed. During the investigation, it was discovered that one of the neighbors convinced Mrs. Smith to add her name on the deed to the home. Access to both the mother and son's bank accounts were also granted. During this time, the neighbor also diverted funds to have plastic surgery. Mrs. Smith was further preyed upon when a neighbor's friend moved in rent-free while she paid for weekly caregiving services when no care was provided. He was also using illicit drugs in the home. APS referred the exploitation to law enforcement and a criminal investigation was started. Mrs. Smith and John were fearful of retaliation. Guardianship was pursued for both clients. Even with law enforcement ongoing investigation and Adult Protective Services continued involvement, the couple continued to exploit and intimidate the mother and son. John continued to be taken to the bank by the neighbors to withdraw hundreds of dollars at a time, even up to the very minute the guardian court commenced. Later, it was also discovered that Mrs. Smith had been physically abused. A protective order in this case would have helped Joy and John sooner. I'd like now to share Karen's story. Karen Jones was 45 years old, mostly bedbound, and she allowed her friend to move in with her after the friend lost her job. The friend then allowed her boyfriend to move into the home. Both were addicted to drugs, and Mrs. Jones was being verbally abused, and they were financially exploiting her. Because Ms. Jones' had mobility issues, transportation was difficult. Her situation did not clearly fall within existing legal protective orders, so it was very difficult for Karen to get help. And finally, I'd like to share Robert's story. 85-year-old Robert Lee was being abused and neglected by his live-in caregiver. Mr. Lee had significant cognitive deficits. He did not clearly fall within existing legal protective orders, and because of his cognitive limitations, it was difficult to get help. Months later, the caregiver was finally evicted, and subsequently a guardianship proceeding commenced. If Adult Protective Services had the ability to obtain a protective order, Mr. Lee could have been spared further abuse and neglect. Elder abuse, and more broadly, the abuse of vulnerable adults, is a serious public and human rights issue that erodes an individual's safety and dignity. For vulnerable adults, abuse is not limited to physical threats of violence and harm, but also includes mental and emotional abuse, abandonment, neglect, isolation, financial control, document control, property control, and other types of control that make a victim more likely to return to an abuser due to fear of retaliation or inability to meet basic needs. Many vulnerable adults are unable to access the resources necessary to seek lasting options or meet their immediate care needs. I thank you for your time, and I will now turn the presentation over to Jennifer Richards to walk through the bill.
Thank you, Jennifer Richards, for the record. As illustrated by Ms. Seaver, existing state law can be strengthened to fully address the unique needs of our vulnerable adult population throughout the state. Currently, 28 states and territories have some form of specialized protective order that provides relief to this population. Sections 3 through 6 of the bill define vulnerable adults. We do have a proposed amendment to this section to align the definition of vulnerable adults with
APS and ensure that, in addition, those individuals age 60 and over, just by purview of being 60 or over, would be covered in seeking this type of order. Section 7 includes the mechanics of the order and how it will work. Notably, the individual is empowered to seek a protective order on their own behalf. However, in addition, under Section 7, it does provide that in certain instances, APS can act as petitioner. Section 7(2)(b) also includes language that APS may refer cases to the public guardian if APS believes that a guardianship is appropriate. There has been an amendment offered in this section from Clark County that we do not oppose. Additionally, Section 7 outlines the relief that may be granted under this protection order, which in short includes restricting contact, restriction of access to specific locations, providing an accounting, refraining from transferring, selling, or disposing of property of the vulnerable adult for a specified period of time. And there's also a provision regarding custody, possession, or control of pets. And when we looked at the 50-state survey, we felt that was very important to include because for some of these individuals, their pets are their life. And that can often be used for abuse and control. Section 8 of the bill waives filing fees. Section 9 outlines the timelines for temporary orders and extended orders. Section 10 outlines the procedure for law enforcement to receive those orders so they can be enforced. Section 11 outlines registry of the order. And finally, sections 12 and sections 13 lay out criminal penalties for violating a protective order. We want to thank the committee for their time in hearing this bill. We especially are thankful to the interim committee and all the stakeholders that have participated in the last several months to bring this forward in Nevada. And we're open to answer any questions at this time.
Thank you so much for the presentation. Really appreciate it. I do have a couple folks so far in the question queue. We'll start with Vice Chair Nguyen, and then we'll go to Assemblywoman Cohen.
Thank you, Chair Yeager. I have several questions. Is that okay?
Yes, please try to ask them as concisely as possible.
I will try to do that. I know that we have guardianship already. So one, what type of due process rights do these vulnerable people get? Like, what if they want to associate with someone and like what kind of due process rights do they get? I'll start there.
Jennifer Richards, for the record, to Chair Yeager, through Chair Yeager to Assemblywoman.
And please feel free to go direct to the member.
Thank you. The proposed legislation is laid out similar to the other protection orders in existing law, with those due process rights of temporary being available and then a notice and hearing for an extended order. Importantly, individuals would be able to pursue these protective orders on their own. In very limited circumstances, APS could act as petitioner, but we were very focused on empowering individuals to pursue these orders on their own.
Can I ask a follow-up, Chair?
Yes, please go ahead.
So, like under a current situation, under a current guardianship, you have to have a licensed physician statement. In this case, how would a petitioner establish that medical need? Would it just be hearsay? Like, it seems like it would just be hearsay or a lack of expertise in that area. Like, how would, under this procedure, how would you establish a diagnosis that a vulnerable person needs, like, assistance with activities of daily living? I mean, we have those kind of like guidelines and protections in a guardianship. I just don't see how that works in this circumstances.
Jennifer Richards for the record. I'm happy to provide some of the other state statutes for you to review and discuss with me. If APS was to act as petitioner in a guardianship proceeding under 159, just having the law enforcement report from APS is enough to petition by province of them being that agency. If an individual is over 60, they would automatically be eligible for the protective order just by basis of age. And then there's some other criteria in section 3, based on where they're living, if they receive personal care, that would also qualify them for the order. And that's modeled after language in our sister jurisdictions of California and Washington State, as well as Oregon.
Do you know how those statutes like compare with our guardianship statutes? I know that this is like a super complex like area that our family court judges, you know, have become more and more like expertise in this area. I just want to make sure that these kind of come together first and can work like in coordination, I guess.
Jennifer Richards for the record, absolutely. I was a practicing guardianship attorney with legal aid prior to entering this role, and I sit on the Nevada Supreme Court Guardianship Commission. The intent is that this protective order would work in harmony with our existing guardianship laws. Our setup is different. When we consulted with the National Adult Protective Services Agency, they actually have a different setup. And these types of orders are built into a different mechanism. So we did adjust this to be Nevada specific to work within our existing statutory framework. But there are individuals that would be eligible for the protective order who would not also meet the criteria for guardianship. So I want to make that clear as well.
Thank you. I'll follow up offline. Thank you.
Thank you, Vice Chair. We'll go next to Assemblywoman Cohen.
Thank you, Chair. And I also have a few questions, if that's okay. I really appreciate this bill, and I'm glad that it was brought forward from the interim committee, but I do have some questions and I guess procedural concerns. So first I'll start off in section 6 sub 8, there's the term personal. And I would just ask if that's not a statute, or ask that even if it is defined in statute, get a definition of personal aid there.
Shannon Bilbray-Axelrod for the record. I don't know if you were cutting out just for me, but I don't know if the other folks got that.
Oh, okay. I'm sorry. Thank you. I was asking about at the end at section sub 8, there's the term personal aid, and I'm not sure if that's defined in statute, but if we could get a definition for that, I would appreciate it. At least for the in the statute, in the bill.
Yes, that's a great question. Shannon Bilbray-Axelrod for the record, and I don't believe we have legal with us, correct, Chair? Right. I can, let me just say for the record, this bill is by no means the final product. I literally it got delivered to me a couple days ago, and so there have been a number, as you see, there's 2 friendly amendments. I'm also in talks with the PD and NJA about certain sections as well. So anything that you see sort of and you want definitions, we can definitely do that. But obviously we are at a little bit of a time crunch, but we have a week. So, but we will definitely get that for you if that is okay, Assemblywoman Cohn.
Thank you. I appreciate that. And then also in section 7 sub 10, it's at the bottom of page 5. I would just ask that also supportive decision making be considered. Certainly this is, and possibly in other places throughout the bill, because certainly, we've legalized supportive decision making. And I think for that for this population, it might be very helpful to make sure that if they do trust and have taken advantage of our supportive decision-making statutes, that's included in this. I mean, I'm sorry, I'm just trying to go fast to make sure that everyone gets a chance, and I know we have another bill. Then my next question is also a big concern. In Section 8, there's automatic attorney's fees or costs and fees. And I was just a little concerned because other temporary protective orders don't come with automatic fees. Additionally, if someone is denied the protective order, are the fees still in play? So I just like a little more information about the fees section and to note my concern with that.
Is that it? Assemblywoman Bilbray Axelrod, for the record, I think the DHHS wanted to speak to this. I will happily work with you, Assemblywoman Cohn, and we can go over this bill a little bit more with a fine-tooth comb if that's all right with you. But DHHS, go ahead and speak. But Assemblywoman Cohn, does that work for you?
Certainly, yes.
Thanks.
Jennifer Richards, for the record. Thank you, Assemblywoman Bilbray Axelrod. I was just going to add that provision was not in our interim presentation. So that was added during the drafting process. So we don't have a vested interest in that provision and are willing to collaborate to get the bulk of the bill passed, if that's an issue.
Thank you. And then my other issue that I just addressed that we don't have to solve today, but I would like to discuss is the length of the protective orders. Since other protective orders aren't necessarily, you can't get a 5-year TPO from your spouse or former spouse. And so I would also like to just maybe discuss that offline. So, and I'll leave it at that. Thank you, Chair. And again, thank you. I do think it's really important, and I'm happy you brought it forward.
Thank you.
Thank you. I think we have a question next from Assemblywoman Marzola.
Thank you, Chair, and thank you for bringing this bill. I do love the intent. My question is on Section 7, subsection 4, and it relates to the immunity from criminal and civil liability. So what happens when a vulnerable adult is under the care of APS and something occurs? What would be the recourse for the vulnerable adult at that point if we are giving immunity to the Department of Health and Human Services, its officers and employees?
Jennifer Richards, for the record, if I may respond directly to Assemblywoman Marzola. Just to clarify, APS does not take custody of adults. We do not remove them from homes. We do not have the same procedure and authority that an agency such as DCFS, which is Division of Child and Family Services, has. So that provision is just providing that APS has discretion to pursue or not pursue protective orders as they deem appropriate for the clients that they serve. And that will be on a case-by-case basis developed by the staff in APS who have the expertise to make that determination. It's to prevent someone from coming and saying, why didn't APS file a protective order on my behalf? Because it should be within the sole discretion of the department whether or not they would act as petitioner. I can also speak to the bill intent is to, of course, work with our legal aid providers throughout the state. I serve as the state legal assistance developer under the Older Americans Act, and we have amazing legal aid providers in Nevada, and our hope is that there will be referrals between APS, and we can work collaboratively to get the people the help that they need.
I would love to talk about the immunity part offline. I know we're kind of in a time restraint. Thank you. Thank you, Chair.
Thank you, Assemblywoman Marzola. Go next to Assemblywoman Summers Armstrong.
Thank you, Chair Yeager and Assemblywoman Bilbray Axelrod for bringing this bill. I do have a question about how this works as far as reporting. Often folks with physical disabilities, and I hear a lot about this in my community, have in-home healthcare workers who might be the first people to notice if there is abuse or suspicious behavior going on that could be detrimental to this vulnerable population. Are they mandatory reporters?
Hi, this is Tammy Seaver for the record. And yes, home health personnel are mandated reporters.
Thank you. May I follow up, Chair?
Please go ahead.
So do I understand with these amendments that you all are requesting that they, on behalf of their person that they are providing services for, could make a report, and then you all would be able to step in to assist and file protective orders?
So as this Tammy Seaver for the record, so as a mandated reporter, they're reported to, contact our office and make the report. A case would be open, and a social APS worker would go out and do the investigation, and that would be the determination of, what steps in the investigation we were going to proceed with, and that does involve talking with the client themselves and what their wishes are. Thank you.
Thank you. One more thing, Chair, if I might ask.
Please go ahead.
Thank you. So does this change in the legislation help that process at all?
Well, this is Tammy Seaver for the record, and it does help in the sense where time we're able to perhaps alleviate the abusive situation sooner and assist the client on being able to, if the person's living with them, is to be able to get them out of the home quicker and keeping them safe.
Thank you.
Thank you.
Thank you. Do we have other questions from committee members? If you have a question, if you could raise your hand, let me know. I'm not seeing additional questions at this time, so Assemblywoman Bilbray Axelrod, our representatives from DHHS, appreciate you presenting the bill. We'll ask you to sit tight for just a moment while we take some testimony on the bill, and then we'll come back to you for concluding remarks. So at this time, I will open up for testimony in support of Assembly Bill 407. I see we have Ms. Karen Kelly on the Zoom. Are you in support of the bill, or are you in a different position?
We're in support with the proposed amendment that we have provided, and I just wanted to provide some information on that.
Okay, great. Please go ahead and provide your testimony. If you could just state your name before you speak, that would be helpful.
Absolutely. Good morning, Chair and members of the committee. Thank you for allowing me to be here. My name is Karen Kelly, and I am the Clark County Public Guardian. As mentioned before, this amendment has been uploaded to Nellis for review and discussed with the department. This amendment specifically modifies Section 7 2B by providing that it only applies to counties less than 100,000, just that particular section. The Clark County Public Guardian's Office does not have the legal authority to investigate the personal and financial history of a proposed protected person or determine if the guardianship is appropriate. Under NRS 253.220, This only provides that the Public Guardian's Office can access the personal and financial information of a protected person after we've already been appointed as guardian. In order to determine if a guardianship was inappropriate, an investigation would need to be conducted and access to all that personal information would be needed in order to move forward with a petition. Gaining access to such documents and information, which is incredibly private in nature, should not be allowed without judicial oversight. As a person has not yet been deemed incompetent, the Public Guardian's Office, as a governmental agency, should not have access to such information until the office has been appointed as the guardian in order for us to develop an effective case plan. If the Public Guardian's Office is investigating and then subsequently petitioning for guardianship, we find that this is an inherent conflict. The Public Guardian's role is really not to determine who in the community specifically needs a guardian. The burden of that proof on whether or not a guardianship is required falls on the petitioner and the court, not our office. We're not involved in cases where the need for guardianship is still at issue. We're there to serve in that capacity once a court has determined that it's appropriate and when there are no friends, family, or any interested party willing or appropriate to serve. Thank you.
Thank you for your testimony, Ms. Kelly. And it did look like you were reading from something. If you wouldn't mind submitting those remarks to our committee manager, that will help them transcribe the minutes. Do we have anybody else on the Zoom who is in support of Assembly Bill 407? I don't see any other supportive testimony on the Zoom. BPS, could we go to the phone lines to see if there's anybody there, please?
Yes, thank you, Chair. To testify in support of Assembly Bill 407, press star 9 now to take your place in the queue. And we will begin with the caller with the last 3 digits of 528. Press star 6 to unmute yourself, then state and spell your name for the record. You will have 2 minutes and may begin.
Good morning, Mr. Chair, members of the committee. For the record, my name is Barry Gold, B-A-R-R-Y-G-O-L-D, and I'm the Director of Government Relations for AARP Nevada. You've heard some of the terrible stories, and I will tell you those are just truly the tip of the iceberg. The first thing I want to say is I am not an attorney. Please do not ask me any of the technical questions that have been discussed right now. What I want to talk about is the need for this and what this does. These are our moms and dads, our grandmas and grandpas who have lived their whole lives. They have worked hard. They have raised their kids. They have paid taxes. We had Senior Issues Day last week, and as Speaker Fryer said, these are people who have paid their dues, and they truly have. Now they find themselves in the position where they need a little more help. How about if I say they need a little more protection? They need a little more protection, and that's exactly what this bill is intended to do, is to allow that to happen and allow that protection to them so they can protect their assets, their lives, and everything else that's important to them. So AARP strongly is in favor of the concept of this bill. You've heard how it's spreading across the country. More and more states every year are passing something like this. So please consider that these are the people who have paid their dues and they really need this help and this protection. So AARP, on behalf of our 345,000 members across the state, strongly support this bill and urge you to pass it. Thank you.
Thank you for your testimony, Mr. Gold. It was good to hear from you. BPS, could we take the next caller in support, please?
Yes, would the caller with the last 3 digits of 237 slowly state and spell your name for the record? You will have 2 minutes and may begin.
Good morning, Mr. Chair and members of the committee. My name is Marlene Lockard, L-O-C-K-A-R-D, representing the retired public employees of Nevada. We are in strong support of this measure. We think it is a continuing piece of legislation to add to the protections of our seniors and many of our nearly 8,000 members of RPEN. We appreciate the bill sponsor in bringing this bill forward, and we thank you for your continued oversight and protection of this vulnerable population. Thank you.
Thank you for your testimony, Ms. Lockard. It was good to hear from you as well. BPS, are there additional callers in support?
To testify in support of Assembly Bill AB 407, press star 9 now to take your place in the queue. Chair, there are no more callers in the queue.
Thank you, BPS. I will close testimony in support. I will now open up testimony in opposition. We don't have anyone with us on the Zoom in opposition. BPS, can we go to the phone lines to see if there's somebody there?
To testify in opposition of Assembly Bill 407, press star 9 now to take your place in the queue. And we will begin our testimony with the caller with the last 3 digits of 500. Please press star 6 to unmute yourself and then slowly state and spell your name for the record. You will have 2 minutes and may begin.
Mr. Chairman, this is Matthew Sharp for the Nevada Justice Association, and I am speaking in limited opposition to the bill, and specifically as to Section 7, Subpart 4, which provides for absolute immunity to the state for any wrongful act that is committed by the state in the enforcement of this particular bill. And our position would be that that's excessive. No matter the best intentions apply, this is obviously everybody's in favor of helping vulnerable adults, but if somebody is an innocent person is injured in the process, they should have some remedy. And so for that limited purpose, we are opposed to the bill. And with that,
Thank you for your
answer any questions.
Thank you so much for your testimony, Mr. Sharp. BPS, are there additional callers in opposition?
To testify in opposition of Assembly Bill 407, press star 9 now to take your place in the queue. Chair, there are no more callers in the queue.
Thank you, BPS. I will close opposition testimony. I will now open neutral testimony. We don't have, maybe we do. Mr. Pirro, I see you are on the Zoom. Are you in neutral? Okay, please go ahead.
John Pirro for the record. Thank you, Chairman Yeager. We are in neutral. We spoke with the bill's sponsor, and we are grateful for speaking with her. We're neutral because we would have to move to opposition if the amendment wasn't accepted, but we are in discussions with Assemblywoman Bilbray Axelrod, and she's going to accept the amendment. Our issue with the bill lies in Section 7, subsection 9C, that creates a new TPO penalty structure. Last session, we worked on AB 19 with the AG's office and the DA's office that outlined the penalty structure for TPOs and EPOs in NRS 33.100. And so we're just asking to keep the same penalty structure that we worked on from last session. We fully agree and support the intent of the bill and protecting vulnerable people. Our issue is only with the penalty structure, and that's it, and we believe that we're going to get it worked out.
Thank you, Mr. Pirro. I don't think we have anybody else on the Zoom in neutral. BPS, could we go to the phones to see if there's somebody there?
Yes. To testify in neutral on Assembly Bill 407, press star 9 now to take your place in the queue. And we will take testimony from the caller with the last 3 digits of 318. Please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Good morning, Chair Yeager and members of the Assembly Judiciary Committee. This is Kendra Bertschy, Kendra Bertschy with the Washoe County Public Defender's Office. I'll just ditto what John Pirro said and just add for the record that we are proposing for the TPO and the EPO, the extended order penalties, to mirror what is currently in NRS 33.100. Thank you for your time and attention.
Thank you, Ms. Bertschy. BPS, are there additional callers in neutral?
Yes, Chair. Would the caller with the last 3 digits of 122 press star 6 to unmute yourself and slowly state and spell your name for the record? You will have 2 minutes and may begin.
Good morning, Chairman Yeager and members of the committee. For the record, my name is Tracy Bowles, Bowles. I am the Washoe County Public Guardian, and I'm here to testify in neutral this morning on Assembly Bill 407. Given the fact that Clark County has submitted a friendly amendment to this bill, we would like to just state that we are in support of that friendly amendment that Clark County has submitted, and for the sake of time, just echo the comments that Ms. Karen Kelly gave to the committee this morning. One other additional issue that we do have with the bill is the broad definition of a vulnerable person. I do think it's important to continue looking at that definition of vulnerable person because it does expand the current definition quite a lot. While I think that there is an interest in expanding the current definition by law because the APS does serve individuals from 18 to 60 now, we are interested in looking at if that definition is too broad a definition. And we would be happy to work with members that are working on this bill to get this where it needs to be. Thank you for your time this morning.
Thank you for your testimony, Ms. Bowles. BPS, are there other callers in the neutral position?
We are currently taking testimony in the neutral position on Assembly Bill 407. To provide testimony, press star 9 now to take your place in the queue. Chair, there are no more callers in the queue.
Thank you, BPS. I will close neutral testimony. And before we go back to our presenters, I did just want to say we obviously had some neutral testimony where there were some concerns expressed. Normally, I think I would recategorize that as opposition, but I do realize the bills are coming out pretty fast and furious and are getting heard very quickly. So I believe that neutral testimony was in the spirit of we believe we're going to get there, but would just continue to ask everyone involved in the bill to try to work on those issues as we approach our April 9th first committee passage deadline. Assemblywoman Bilbray Axelrod, would you like to make concluding remarks on Assembly Bill 407?
Thank you. Thank you, Chair. I know we have another bill to listen to, but I just, I will say in the spirit of the neutral folks, we will do everything possible to get there. So, so thank you for your time, committee, and hopefully, well, I'll see you soon.
Thank you, Assemblywoman. DHHS, did anyone want to make concluding remarks there before we close out the hearing?
Thank you, Chair Yeager. This is Jennifer Richards for the record. Just wanted to respond that we're trying to cast a wide net so no one gets left behind that needs this help. And we're willing to work on the fine points of the bill because the intent and the goal is what matters. And there's a huge need in our community for this protection order. Thank you.
Thank you so much, Ms. Richards, your colleagues there, and Assemblywoman Bilbray Axelrod. Appreciate your time this morning. Hope you have a great rest of the day. I will close the hearing now on Assembly Bill 407, and I will be presenting the first bill on the agenda, which I hopefully will not take us very long. So I'm going to hand the virtual gavel over to Vice Chair Wynn, and I will take the virtual presentation table.
Hi, we are going to start, and I will open the bill hearing on Assembly Bill 394. It provides that members of a mobile crisis response team are immune from civil liability under certain circumstances. With that, I will turn it over to our very own Chair Yeager to present when he is ready.
Thank you, Madam Vice Chair, members of the hardest working committee in the building. For the record, I am Steve Yeager, representing Assembly District 9 in Southwest Las Vegas. I am honored to present Assembly Bill 394 to you this morning. As some of you may recall, at least those of you who were in the building last session, we passed a provision in Assembly Bill 236, and again, this was 2019. And in that very large criminal justice reform bill, we directed the Commission on Peace Officer Standards and Training, also known as POST, subject to available funds, to develop and implement a behavioral health field response program. The purpose of that provision was to improve responses to people in crisis by allowing behavioral health professionals, either by telephone or video, to assist law enforcement to de-escalate, stabilize, and resolve crisis situations that are happening out in the field. In other words, the program allows for mobile crisis teams to operate via video or phone. That's particularly important in our more rural areas of the state, where sometimes the nearest mental health provider could be very far away, sometimes even hundreds of miles away. So this bill in front of you, well, before I get there, I guess I'll say, as noted, we didn't fund that program. We established it in Assembly Bill 236, but it was subject to available funds. So I have some good news. We have identified and located a grant funder interested in investing in a program like a mobile crisis response in the state of Nevada through a multi-year grant. To prepare for the likelihood of securing this funding, we reviewed our statutes and believe that including immunity for mobile crisis response team members is important. Assembly Bill 394 in front of you would provide immunity from liability to encourage behavioral health professionals to participate as members of a mobile crisis response team. We do not want them to decline to be a part of this program because of concerns about a liability risk. In this case, and as the bill states, immunity only extends to those situations in which the mobile crisis response team member is acting in good faith and their actions are not considered to constitute gross negligence or willful, wanton, or intentional misconduct. So this is not blanket immunity. And in the other section of the bill, there's currently no statutory definition for mobile crisis intervention services in our state. So Assembly Bill 394 on page 2, so if you flip the bill over, you'll see the definition there. It makes clear exactly what these services are. Mobile crisis intervention services are important because they support law enforcement with complex behavioral health situations that they are often not fully trained to handle and often can result in really bad outcomes for the individuals involved. This model can reduce the number of involuntary mental illness holds and hospitalizations. It can divert people from jail, and it promotes voluntary participation in treatment services, which we certainly want to encourage whenever we can. Having the help of behavioral health professionals can also reduce the degree of the crisis and can result in fewer adversarial and confrontational episodes faced by law enforcement. Madam Vice Chair, members of the committee, that is the entirety of the presentation of the bill that I have this morning. There is not anybody else to testify with me, so I would welcome any questions at this time.
Thank you, Chair Yeager. It was so quick and so thorough that I haven't received any messages from people, so I am just going to be looking at the screen. I see Assemblywoman Krasner waving that she has a question, so I will go to her first.
Thank you, Vice Chair Wynn. It's actually not a question, it's a comment. I just wanted to say thank you so much, Chairman Yeager, for bringing this much needed bill. Thank you.
Thank you.
Do we have any other questions from committee members? Going once, going twice.
And Madam Vice Chair, I'll mention too, there's going to be some testimony, so there may be questions after that, and I'd be happy to answer those at that time as well.
Well, I thank you for that. I will keep that in mind, and if we have some follow-up questions after testimony in support, opposition, and neutral, we will go back to you at that time. Are there any people that you would like me to ask to stay on the line to answer any of those questions? Do you anticipate?
I don't believe so, Madam Vice Chair. This is Steve Yeager. Hopefully I'll be able to handle those questions. I think the opposition will be pretty focused and understandable.
Okay. Broadcast services at this time, if we can begin testimony in support of Assembly Bill 394. I remind callers to please clearly state your name for the record before speaking, and please limit your testimony to 2 minutes. And with that, we can begin testimony in support.
To testify in support of Assembly Bill 394, press star 9 now to take your place in the queue. And we will begin with the caller with the last 3 digits of 679. Press star 6 to unmute yourself, and then slowly state and spell your name for the record. You will have 2 minutes and may begin.
Good morning, Vice Chair Wynn and committee members. This is Gabrielle McGregor, GABRIELE, MCGREGOR, with the Ferrara Group, representing the Nevada Resort Association. We are here today in support of AB 394. It is not uncommon for our security personnel to be required to intervene in crisis situations, so the protections provided in this bill are much appreciated. Thank you very much.
Thank you. If we can go to our next caller in support.
To testify in support of Assembly Bill 394, press star 9 now to take your place in the queue. Vice Chair, there are no more callers in the queue.
At this time, if we can go to callers in opposition of Assembly Bill 394.
To provide testimony in opposition of Assembly Bill 394, press star 9 now to take your place in the queue. And we will begin with the caller with the last 3 digits of 500. Press star 6 to unmute yourself and then state and spell your name for the record. You will have 2 minutes and may begin.
This is Matthew Sharp for the Nevada Justice Association. Please the committee. I am speaking in opposition of SB 394, and our particular concern is twofold. First, I frankly don't understand the need to provide immunity or a level of immunity for this particular type of service. It's not to criticize the service. It's a laudable service, just like it's a laudable service to be a volunteer for a charity or such. But there is a level of responsibility that we expect in our society, and I think it's important to understand that gross negligence is a standard legally that is very, very difficult to meet. I mean, as an example, it would be akin to driving drunk blind. That's the type of conduct that would arise to gross negligence. It's the law calls very extreme negligence. So I don't think that type of immunity is necessary. Secondly, I think the definition of mobile crisis intervention services is very broad, and it would include people that don't fulfill, I think, what the intent of the legislation is. For example, we heard from the casino industry. Well, the casino industry, they should be trained to deal with people who are customers who may or may not have mental disorders, but they shouldn't be given immunity for their negligent acts. So I think that nobody is against the concept of a mobile crisis intervention service to provide service to our community, but it should be done so in a responsible and fair manner. And with that, Mr. Chairman, I'll answer any questions.
If I could go ahead and have you maybe stay on the line, and we'll see if there's any more testimony in opposition, and if our members have any questions for you specifically that our chair can't answer, we'll defer to him.
If you have recently called a meeting and you'd like to testify in opposition of Assembly Bill 394, press star 9 now to take your place in the queue. Vice Chair, we don't have anybody else in the queue.
Do we have anyone else in the queue in neutral?
I don't believe we have. Oh, all right, somebody's just joined. Caller, user number 2, please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Hello, this is Chuck Calloway, Callaway, representing the Las Vegas Metropolitan Police Department. I'm so used to saying my badge number after my name, so I apologize for that. I'm here neutral today on the bill. I think that most teams are very important, and they do help with responding to crisis situations. And over the past year, we've heard a lot of discussion about qualified immunity involving police officers, and I think that this bill illustrates the reason why, if someone is doing a very difficult job and dealing with folks that are in crisis, as long as they're acting in good faith and they're not being malicious or violating the law, that immunity is a component that helps them do their job without fear that they will lose, their livelihood when trying to help others. So I just wanted to put that on the record that we're neutral on the bill, but we think it's the most teams are important. Thank you.
Thank you, Mr. Callaway. Broadcast Services, do we have anyone else on the line in neutral?
To testify in the neutral position on Assembly Bill 394, press star 9 now to take your place in the queue. Vice Chair, there are no more callers in the queue.
Thank you. I will turn this back over to the committee to see if we have any follow-up questions, especially based on that the opposition testimony. I am kind of looking around. Seeing I have a question from Assemblywoman Summers Armstrong.
Thank you, Vice Chair Wynn and Chair Yeager, for the presentation. I just want to clarify that we are speaking of, as Officer Callaway mentioned, those folks who are going out in the capacity of helping to respond, which is what I'm reading in the bill, to crisis situations involving the police. You mentioned post-behavioral health Bill 236 from last time, where you wanted de-escalation. So we're speaking specifically about those folks, and I think they're called the most teams. We have them in West Las Vegas to help us with issues when we have homeless or folks with having mental health crises, and to help get them help. Is that correct?
Steve Yeager, for the record, that is correct. It is a focus on trying to help law enforcement deal with some of the more difficult calls that they respond to, which typically involve people who are experiencing a mental health crisis. So the idea is that there would be a behavioral health professional available, likely by phone or by iPad, to be able to sort of virtually step in and help on that call. So we're talking about those individuals who are providing that, sort of in the field, but through virtual means, crisis intervention. That's who the bill is intended to encapsulate.
Madam Vice Chair, if I may follow up.
Go ahead.
Would this also apply if there was a person, a person to assist in person? I know originally, this is new to me, that there would be virtual, but I know that I was hearing through my community that they actually had people in person going in on the most team. Would that also apply to them?
Steve Yeager, for the record, it indeed would. I think maybe the confusion is that we call it a mobile crisis unit. So, the idea just being that the behavioral health professional is being transported to the scene, whether it be the actual person's being transported or it's through audio-visual technology. So it would include those individuals who are interfacing face-to-face with those who are experiencing a mental health issue.
Thank you so much.
And I am looking around to see if I have any more people that are interested, and seeing none, I will turn this back over to you, Chair Yeager, for any closing remarks.
Thank you, Madam Vice Chair, members of the committee. Steve Yeager, for the record. Certainly appreciate the opposition, and I think everyone who knows me knows that I'm generally not in favor of immunity. I believe our civil justice system requires people to pay for their acts of negligence. Generally agree with that. I think here may be a situation where we want to provide some limited immunity, and really here's why. These are really difficult calls for law enforcement to have to respond to, and certainly not a knock on law enforcement, because we expect them to do a lot out in the field. But over the course of the last couple of decades, I think not just here in Nevada but nationwide, there really been some very public events of situations just escalating in a way that I think everyone would agree they didn't have to escalate. And a lot of those are due to folks who are experiencing mental health crisis, experiencing results of illicit drug use. And so the concern here is, I want to at least consider giving this immunity because I want behavioral health professionals to want to be involved in this process, because really, if they're not involved in the process, what's going to happen is the default is going to be arrest the person or commit them to a hospital. And that is usually not the most effective means for treatment. It is the most expensive means for treatment. And in the rural communities, it's a big problem because if you have to take someone to a mental health facility, you might be driving for 3 hours, and that is an officer that we are taking off of the streets to do a mental health transport. So we all, I think, have an interest in making sure that if we can get the person immediate help, if we can get them to agree to take medications, to be with family members, that's a service that's very, very valuable. And so I bring this bill, although contrary to my normal belief on these issues, because I think it's going to be important for us to have this provision to ensure that we can actually find providers that want to provide these services. And again, we are looking at potentially receiving grant money, no strings attached, that will provide for funding for us to be able to do this. So hopefully that answers the questions. I'll continue to work with the opposition to see if there's some kind of compromise that can be reached, but I would really hate for Nevada to lose out on what is a very exciting opportunity in the next year or two. And I simply don't believe we can wait until next session because that opportunity will be lost. So with that, Madam Vice Chair, members of the committee, thank you for your time and attention to this bill. And that concludes my remarks.
Thank you. And at this time, I will close the hearing on Assembly Bill 394, and I will turn the virtual gavel back over to Chair Yeager to close out the meeting.
Thank you, Madam Vice Chair, for handling that hearing for us. Committee members, this means we've gotten through our agenda items. As far as bills are concerned, we do have one more item, which is public comment. Just by way of reminder, we reserve up to 30 minutes for public comment at the end of each meeting. Public commenters will have 2 minutes to provide public comment. Public comment is a time to raise matters of a general nature within the jurisdiction of the Assembly Judiciary Committee. BPS, could we go to the phone lines to see if anybody would like to give public comment this morning?
To provide public comment, press star 9 now to take your place in the queue. And we will begin with the caller with the last 3 digits of 556. Please slowly state and then spell your name for the record. You will have 2 minutes and may begin.
Anne Marie Grant, ANNEMARIE, GRANT. My brother Thomas Purdy was killed by Reno police. Officers Jorge Aparicio, Christopher Good, David Tallman, and so I wanted to read something that I received from somebody who actually had an encounter in January with Officer Maxwell, who was one of the 4 Reno police who hogtied my non-aggressive, mentally ill brother who was in a mental health crisis. And what it says is, this is about Reno PD and Officer Maxwell. Reno PD tried to kill me. Officers Lupe and Maxwell. They tried setting me up with drugs that had no idea I knew what was going on. I saw what they were doing. They surrounded me, 7 of them. Those 2, Maxwell and Lupe, were the main ones trying to do the setup. I didn't let myself get set up. I told him to stop harassing me. They started beating me up. A witness jumped in. She was beaten up too. It's in a statement. After me surrendering and saying, please stop, Maxwell stood up in front of me and Lupe still behind me. I felt a gun barrel. I said, please don't kill me. Please don't kill me, at least 4 times. And he let go of the taser. Hundreds of volts through my head, right in the back of my head, falling. I basically died and came back alive after like 10 minutes. Realizing that I remembered everything, they asked immigration to deport me. Knowing that there were cameras in Walgreens on Kiski near Atlantis, they erased all the evidence. So That same officer was one who hog-tied my brother. I am going to put in a public records request for that body cam footage of this incident with that man, and I'd be more than happy to share the results that I get with you. Please support bills that promote transparency and accountability. Thank you.
Thank you for your public comment, Ms. Grant. BPS, are there additional callers for public comment?
Caller with the
Chair,
last
please
three
hold.
digits.
We are having.
Oh.
Excuse me. We are back and running. Excuse me.
All right, caller with the last three digits of 570. You are unmuted. Please state and spell your name for the record and begin your public comment.
Good morning, Chair and members of the committee. My name is Leah Case. I'm here today with my daughter, CJ, and we are here to read you With That Moon Language. Admit something. Everyone you see, you say to them, love me. Of course, you do not do this out loud. Otherwise, someone would call the cops. Still, though, think about this. This great pull in us to connect. Why not become the one who lives with a full moon in each eye, that is always saying with that sweet moon language what every other eye in this world is dying to hear? Thank you.
Thank you for your public comment, Ms. Case. BPS, is there additional public comment this morning?
To provide public comment, press *9 now to take your place in the queue. Chair, the public comment line is open and working, and there are no more callers in the queue.
Thank you, BPS. Thank you for your help. As always, I will close public comment. Do we have anything else from committee members this morning before we talk about where we go from here? Okay, I don't see anything. One thing I did want to say before we talk about the schedule is I wanted to wish a very happy 11th birthday to Henry, who is the son of our Vice Chair, Wynn. It is Henry's birthday today, and he is up here in Northern Nevada spending time with his family and with his mother. So, Henry, if you're out there and you hear us, we hope you have a really great birthday today. And hopefully you get a big helping of cake, donuts, pie, whatever you want. Happy birthday. So, committee, thank you for this morning. I know we took us a little while to get through everything. While we were in committee, we had agendas posted. So as of right now, we have agendas posted for Friday and then Monday through Thursday of next week. We are going to have a meeting next Friday. There'll probably be a large work session, but we don't have the agenda yet because we're figuring out what we're going to work session. So far, all the agendas list an 8 o'clock start. And as you saw from today, we're probably going to need that extra time. So I would love to give you a little bit more time in the morning, but hopefully we can do that after next week when we get through our deadline. Tomorrow morning, I'm going to be presenting the consumption lounge bill, so that should be a pretty fun hearing for a Friday morning. And just by way of preview, there are some amendments we're working on that bill, and I'll make sure to get those out to you, all of you, sometime later today, so you have a chance to look at those. It is not a complete rewrite of the bill, though, so it shouldn't be too difficult to get through. So 8 o'clock tomorrow, 8 o'clock the rest of next week. Until then, I hope you all have a great day. And again, pat yourself on the back. We are through halfway, 60 of 120. And if you haven't yet, you should all be receiving a small treat from myself and Assemblywoman Hanson, who she is holding it up in front of the screen. So congratulations on getting halfway through. We'll see you tomorrow morning back in this committee at 8 a.m. This meeting is adjourned.